My name is John Gordon. I'm professor of philosophy at Vytautas Magnus University. I'm hosting this international conference, The Future of Legal Education, which is part of our EU-funded project, Future Law, Ethics, and Smart Technologies. And this is the second major conference within our project, and I'm very happy to host this event and to have so many great speakers here at the conference. But I do not want to talk a lot in the beginning, but only mention a few things, and then I will moderate basically the whole event. We have the, of course, interesting situation that many of our participants of the conference are online, and they are not here at the moment due to, some understandable reasons as well. You're very well familiar with the current COVID situation. But nonetheless, I'm happy to see still quite a few people here in the audience, and I would like to stress the importance of the topic, the future of legal education, in particular against the background of the very fast development of artificial intelligence, which is then used in different applicational fields, such as law. And that is causing an issue because there are some certain problems, just to mention machine bias in the context of AI, and at the intersection of law and ethics. But we will hear more about these issues in the conference. I would like to first introduce very briefly our two colleagues who will give an opening address as well. First, Justyna Kugytė. She is advisor to the Minister of Education, Science and Sport of the Republic of Lithuania, and a former alumni, or she's an alumni of the Faculty of Law. And then the new Dean of the Faculty of Law, Professor Dainius Šalimas, from Vytautas Magnus University. He is a former constitutional judge and president of the constitutional judges. But first, I would ask Justyna Kugytė to say a few words, and the floor is yours.
Thank you. Dear colleagues, dear participants of this event, live or at a distance, it's a great pleasure for me to welcome you at the International Conference of the Future of Legal Education. Digital technologies are transforming our lives. It increases the speed and the quality of services, improves communication and cooperation. It opens the new opportunities for education. We have recently started a digital transformation in education project called EdTech. The project goal is to implement the latest educational technologies by creating an initiative and support system for digital innovations and to develop digital competences. We seek to increase educators' digital skills and enable the use of the latest educational technologies in the education sector so that the digital content is accessible to every student and tailored to their individual needs. Better digital skills support the development of innovation culture in schools, colleagues, and universities, and their openness to technology-driven solutions. We believe that together with digital technologies and innovations, we can build more effective education system and improve the quality of learning outcomes. I'm glad that Vytautas Magnus University Faculty of Law contributes to the scientific debate in education, law, and technology themes, touching on relevant and problematic issues, what is important for achieving positive change in the training of lawyers. I'm very excited to hear the presentations, and I wish you a good discussion. Thank you.
Words greatly appreciated. And now, please, Professor Zalimas, it's a great pleasure to have you here today and to hear your opening address. Thank you.
Dear colleagues, friends, ladies and gentlemen, it's my honor to welcome all of you in this important conference, and also using this opportunity, first of all, I would like to thank all who contributed to this important project and organized this conference. You know, the theme of future legal education, I think it's both eternal, but it's also very important because we have to think how to reconcile what is inevitable on the one hand and what is also eternal on the other hand. I mean, what is inevitable? That is the digitalization of our life, in particular in times of crisis like we have now. I mean, pandemic, and when digitalization becomes the only tool how to maintain connections, how to adopt even decisions, even laws. And therefore, it's very important also to have knowledge to introduce necessary tools in our legal education in order to have modern lawyers who know not only theory but also who are very flexible by working in practice with the current tools offered by digital science. On the other hand, we shouldn't forget that the law as such is based on universal or eternal values. We in Lithuania, like in Germany and many other countries, we have eternal constitutional values like the rule of law, human rights, and democracy. And sometimes maybe what can be as worrying trend, we can notice that we have less respect to the rule of law, less respect to democracy, and sometimes maybe it's also due to the fact that we are paying more and more attention to very specific fields. So the main challenge, I think, for the future legal education, that is how to face the challenge of digitalization, how to be modern without forgetting about what is eternal and what is the basis of any modern democratic legal system as well. I think that this conference will really contribute to this discussion, how to reconcile between what is eternal and what is inevitable. And I wish you all fruitful discussion and also to expand your friendly relations and to maintain them in the future in order to find the best possible decisions in this important field. So thank you very much.
Thank you very much for your address. Greatly appreciated. I think quite a few important things have been mentioned here. But now let's start with the conference itself. Before I introduce our next speaker, we will hear or we will have a 1-hour session. That means a 40-minute presentation followed by a 20-minute QA session. Our next speaker is Tanel Kerekmeh, professor and director at Tallinn Law School at the Tallinn University of Technology in Estonia. His topic is Blindfolded Themis with a Computer, How to Reconciliate the Data-Driven Society with Legal Society via XAI. So I'm very happy, Tanel, to have you here giving the first keynote lecture. And the floor is yours.
Thank you. I hope I can open the presentation here. I think it's here, yeah. Yes. All right. Thank you, John. And first, I have to say that I'm very glad to be here with Vytautas Magnus University. We have had a very good cooperation. So, first, thank you. My presentation would actually indicate what are the concerns related to using AI and using data in the legal decision making. So we could assume that there is at least certain digital divide between lawyers, also between judges, and we could also assume that there is a digital divide between the law schools that are preparing the lawyers. And I would start with some of the let's say Estonian experiences, and then go to the main dilemmas. Yes, Estonia is very proud of being the e-country, e-governance country, trying to use the data and give the digital services to the citizens, also to the citizens of other countries through the e-residency. And data market is certainly the biggest market in the world. And it also concerns the data that we are using in lawyering and legal decision making. So we have 70 databases that are like owned by the state, but also the others. So there is a lot of information. And now the question is, how can we use it in better lawyering? The central institution here is the Center of Registers and Information Systems. So basically, RIC is a state agency under the jurisdiction of Ministry of Justice, and they are responsible for establishing innovative environment, providing integrated e-services. We also have the principle of, very strong principle of once only. So if the state asks you the information, they cannot ask the same information again. So we have the institution in the center that tries to administer all this data. But if we go to Estonian e-justice, then similarly to Lithuania, we have the e-file system. Only that I think maybe we have a bit more ambitious ideas in that regard. As I acquainted myself with the Lithuanian situation, it's more the exchange of digital information. In our case, the e-file is the central information system, provides overview, different phases of judicial procedures, and it enables actually the simultaneous exchange of information between different parties. So we also have a court information system called KIS. So offers one information system to all of the types of court cases. And there is a description of that. But if to go even further, I think that digital data exchange concerns very much also criminal records database. And this can be accessed by any citizen, but there are also certain restrictions. So, an unauthorized inquiry about another person is a paid service, €4. But it seems to work pretty pretty well. So you basically apply for the information and you get the answer in 2 days. It's very easy to request for the information. One of the concern in Estonia, what I see is, in general, e-governance cannot live without the support of AI anymore. And therefore, we need a lot of innovation that is expensive. And we don't have so many resources to support this innovation. So we have to buy the innovation from abroad. And there is a great security concern, of course, especially if we go to the very serious spheres like judicial or legal decision making. Those are the Estonian developers here, and they are dedicated to the e-justice. So, I mean, you get the presentation later. Everyone has a website and a description of what they do exactly for e-justice. So you can visit the websites. So why e-justice? You know, why we are going to be more and more digital? I think this cost effectiveness first. Last 20 years, we still have the same amount of judges. Of course, they are more expensive because the new courthouses and let's say the administration of justice. My daughter is also assistant to judge, so I maybe know more about let's say how the judiciary is accepting the new digital reality, and I see a clear divide because the judges are not in the same age and they don't have the same perception or same skills maybe. So the judges also made a kind of criticism that instead of investing to the innovation and the big courthouses, there should be more awareness and more training, you know, for the judges, not only to the new ones but also those who are already working. But still, I think cost effectiveness is one of the drivers. We have civil cases doubled, but the same amount of judges. And lots of routine can be managed by AI. So you see there is a list of what is done already by AI in Estonia. Some of those things basically are done in many jurisdictions, but I think maybe the very innovative maybe area is that a person may write a text in a free format, and the AI will structure this text into the correct format to be forwarded to the court. So and the AI may also ask, you know, if something is missing, you know, then turn back to the person and say, okay, you put this or that information. So also the draft of the judgments, certain part of the judgments can be composed by AI. Of course, there is a need for human control, but it would save a lot of time. There is also the program called KISS 3.0 that makes easy to conduct the intelligent search in many ways. So basically you can put the phrases, you can find the relations between different phenomena and different parts of information. Even if the spelling is different, even if the terminology is different, the AI may find, you know, the similar, let's say, sections from the text. And the AI is advising the assistant to the judge to review the document accordingly also. Maybe also the inquiries related to the proceedings I mean, the AI helps the court system to find out the facts, like the real estate database, the database related to cars, like objects, also the citizens portal. We can find out whether the person is having a legal capacity or what is the criminal record behind very quickly. So this seems to be very useful, and you know, it replaces. I mean, the AI can replace the human being clearly doing this routine work. Maybe one of the very important tasks of what our AI-based e-justice system can do is that we can find the right law. I mean, there are hundreds of pages sometimes referring to the legal text, and Riigi Teataja is the national gazette, so the algorithm is able to find relevant cases from Supreme Court, as well as the relevant legal norms from Estonian, but also from international law already, like European law. So just to go to be a bit broader, what are the use cases of AI related to legal decision making? It's not only judicial system where we use AI and digital approach. It's the state info system in general. So the AI finds out the anomalies and incidents that are threatening the state info system. Road administration, for example, all about the road quality, traffic accidents, speeding problems, analyzing the risks of prisoners, all the chatbots that help citizens to understand the law, and there are all other ideas. Of course, sometimes there is also criticism that we are too digital, that we are doing innovation because of innovation. And I think the very interesting maybe example is related to the speeding, that we have these cameras that you know, make a photo of the car that was going too fast, and then it was also automated so that not the physical person is composing the fine, but the camera basically does it by itself, you know, automatically. And if there is a problem, then the person can go and complain. But now we introduced also a new system, which is, I think, sympathetic in a way that if the police stops a car which was speeding, then the driver has a choice to pay a fine or to have a cooling down stop. It means that, you know, you have to sit in the car for, let's say, 30 or 40 minutes next to the road, which is kind of sympathetic because everything is so technological. For my surprise, many people still they chose fine, because they don't have a time to sit in the car like 40 or 45 minutes. We had a pilot project, but let's see how it goes. So in general, using the AI by lawyers all over the world can be, you know, we can have a categories of that: due diligence, prediction technology, legal analytics, document automation, and so on. I mean, maybe for lawyers, practicing lawyers, the electronic billing is the most useful. It is usually very time-consuming. And now the question, how can robots substitute the legal decision makers? So, as in the Estonian case also, clarifying the sources, analyzing the arguments, textual interpretation, and trying to find the categories, being fact determiners. So just to become more philosophical and see, okay, we all agree, I think we all agree in principle that all this routine can be replaced with the work of a machine. I mean, that is controllable. There are certain facts and numbers. For example, the procedure law, what are the phases, 24 days, you know, who has to sign. This is all understandable. But if we go to the real decision making, where is the margin of appreciation, then we have, of course, more problems. There is one example. There is a Canadian professor, Randy Coble, who worked together with Japanese, and they developed an algorithm that tried to pass the Japanese bar exam. And you see accuracy level for people like Japanese local lawyers who try to pass the bar exam entry level, then it was 85, and for AI it was 94. So the researchers claim that the AI is learning faster and is smarter. Then this has been adopted in a way by, this idea has been adopted by the Chinese internet, Chinese, let's say, policymakers. We have already at least 2 internet courts in China. Also, they are a bit restricted because they are only dealing with e-commerce cases, but still they make deliberative decisions. And there is a real court case, actually, that you can have with your gadget, with your phone. And the Chinese, I've been in Beijing a few times, they say they really want to develop it more and have also maybe administrative procedure and civil procedure covered with this kind of technology. So the best with a question mark, because we actually don't know what is in the black box. The Hebei Supreme Court in China developed the intelligent trial software or AI system, helps helps courts digitize statements, classify documents, so on. It looks like that, as the picture below. And the Beijing judicial system uses a robot, Xiaofa, which can answer 40,000 litigation questions and handle 30,000 legal problems. So it's a very developing area. I think in Europe it is commonly perceived that AI and digital judicial making, not lawmaking, but let's say decision making can be used on online dispute resolution quite successfully, because the margin of appreciation is not so visible. You have certain facts, you agree or not. So there are certain experts, and the expert opinions are available. So ODR, or online dispute resolution, could be maybe the flagship in Europe. And there are certain concerns, of course, using the AI in this field. Maybe the first institution who made a very strong statement was Interpol, who basically supported of using AI, who could again use the data, but as you see the last line, very much emphasized there must be a concept, there must be prototype, there must be evaluation and approval. And in Estonian case, as I'm out of Estonia now, I can be a bit critical. Sometimes I've been thinking, you know, we have all these AI use cases, and the question is, do the good lawmaking principles, do they apply also when we are launching the new AI cases? Because some of those principles say, or these principles actually say that a service provided by the government must first be useful for the citizen, not for the government itself. And then, you know, the question is, where is the inclusiveness, where is the awareness? So I will maybe skip those slides, data protection and AI. Most of the people know that there have been concerns about, let's say, facial recognition. But despite of all these discussions, Estonian public government wrote an article a few years ago, or 1.5 years ago, saying that we are launching the robot charge. And I was actually very much astonished, you know, because I didn't hear about this project before. It was in a journal called Wired that all the nerds and IT-minded people read. Suddenly, there was an article, we are launching the robot charge. So AI-powered charge supposed to analyze legal documents and other relevant information and come to a decision. And I called to the Ministry of Justice and I asked the Chancellor, what is this all about? I don't know. And she said, I don't know either. So it was basically the very ambitious kind of, how to say, marketing plan of Estonian government to say we are also innovative in this field. Later, I think we understood, or the government understood, after the severe criticism, that we cannot play with these kind of ideas without consulting the experts. Because actually, the robot charge, or the claimed to be a robot charge, was basically only the pilot project, the algorithm that was dealing only with small uncontested claims, parking tickets, child benefit cases. So it was not the charge, it was not even the assistant to the charge. It was something that was processing the data, but was presented as a charge. Then I have to say we got a lot of delegations to Estonia who wanted to see the charge, something like the Chinese one was. And for their disappointment, they left without seeing that charge. And the government, as I was like dealing with the AI and this area, they sent those people to me, to my office. So I saw Japanese, Romanian, I don't know, Danish, and then some other delegations, the journalists, who were very excited to see the robot charge. And then I had to say, sorry, you know, it was maybe, let's say, more like marketing, you know, of the idea and the general idea. We're gonna be more digital, but I don't know. I think now we learned the lesson that we cannot really flash with the ideas. It was just before the European Union and the other great stakeholders started to think or claim that there are also certain very possible threats when using the algorithms in decision making. So again, can we do that? There are certain research examples. 2004 in Washington, the researchers tested the algorithm's accuracy forecasting US Supreme Court decisions. And they got a very good percentage, 75%. against 59 of human experts. And there are other examples here. So I think down there the European Court of Human Rights experiment or the researchers experiment 584 cases related to Article 3, torture and degrading treatment, also Article 6, the fair trial and the privacy, Article 8. So basically 79% of the cases were predicted. So it made many or several researchers over the world to say that maybe we should think about of replacing the judges. There was a French researcher who had a different idea. We can use the AI to help correct the biased decisions of human judges. So if you have a judgment, then the AI may check it out. If there are any biases like political, religious, whatever, and then present the report to the court. But this would go very much against of the independence of judges, of course. I would also maybe touch or demonstrate few of the use cases that are used in the world. First one, introspection. This is US-based patented AI model using deep learning, predicts the litigation risks for lawyers. And the model can also be used so that if the client is using that, this introspection goes to the emails and documents of the computers of the company or private person and gives the early warning of the risky text. This sounds a bit, how to say, scary in a way if the AI is just running around in your computer and trying to find risky things. Ravel Law and Lex Machina, they are assisting lawyers with a legal strategy and predict the judge's actions during the trial. Maybe one of the most interesting for me personally is the premonition. This is the American, again, innovation or technology that can be used by the law firms. There is a case coming in. You see the win rate by lawyers, taking account their history, how successful they were in this or in that sphere, win rate, what could be the hourly rate for that particular lawyer, average case length. So looks a bit unhuman, yeah? Because in the end, you have this one successful lawyer who deals with all of the cases. So if you are the beginner or if you are specialized to whatsoever, then you are left aside. But I know that this premonition is used by several law firms in the US. There are many of those kind of innovative technologies. I will not go into all of them. Maybe just to mention Split Up in Australia, which is the AI that tries to make a proposal how to divide the property in the case of divorces, for example. But also the last line, Latvia. I'm not so aware how they do now, but there was this idea that the AI may predict what's the cost of the court case. But I think it could also be dangerous, because if the AI says this case would cost 20 million to the state, then the state, or actually the judge, may avoid, to go on with the case. Enormous burden. So I don't know how fair it would be used, this kind of technology. Also, the European Parliament has been critical in the field of how AI can be used in a justice system. And basically, the last line here says, the justice system must remain in the hands of judges and prosecutors. There is also ethical charter elaborated some time ago. And I think the fundamental rights, non-discrimination, quality and security, when using AI, this is all understandable. But maybe the last one, the number 5, the principle on the user control is something kind of new and needs further interpretation. So all these kind of AI systems should be under human control, clearly. Yes, maybe I skipped that. I already told that it could be that procedural law is a good playground for AI. But why to be careful before replacing judges and lawyers? There are also opinion leaders from Google, for example, Rob High, who said the biggest risk is giving up the human responsibility. As actually, when we were, I was reading the articles about of how in America, in United States, the judges are using these assessment tools or prediction tools. They have no idea how it works. And Richard Posner, who is a famous legal philosopher, says judging is a mix of skills. And it's not only like data-based, it's a research, language, logic. I mean, there are many different aspects. So main theoretical problems is that the AI is not able to identify the normative principle that links or separates the cases. Also, the term living legal practice, as vague as it is, makes maybe sense. And I give you one example. I was speaking one of the startups in Estonia, Avocado. Yeah, they are different. Hugo Legal and others. We try to do cooperation in our law school with them, and they are dealing with the smart contracts. So they put together the best contracts for the client based on big data. And then I asked, where do you get this data? Okay, this is big data. This is the best practice. And I asked, is it possible that something that is proposed to the client is also illegal or barely illegal? And they say, yeah, it could be, because it's the best practice. It's not let's say, it's not guaranteed that this is like according to the is in accordance with the norms, but it's the best practice that is available in the market. Also, the megatech and natural law and positivism, this is something that we could maybe revisit again in this context of allowing the AI to make some even the quasi-legal opinions. Sorry. Black box, of course, has been discussed a lot, but there are no standards of how to open this, at least for the awareness of citizens, but also for professionals. So there is a lack of explainable AI. There is one example of the quite recent presentation of the Justice of UK Supreme Court, who was actually concerned that we are getting comfortably numb comfortably numb. As we are alienated from the digital developments more and more, we don't understand what is in a black box. So there is ignorance among lawyers and in a society generally. We don't understand how it works, so we accept it by default. And the second concern was the secrecy surrounding coding. And I have now actually a project in my law school. I have to evaluate the MVPs, minimum viable products, that the IT guys are developing in the field of medicine, in the field of cybersecurity, and I have to assess the ethical and legal risks. But what I get is like 100 pages of non-understandable text for me, because it's written in IT language. So, I mean, there is this gap, you know, between two tribes still, or maybe more tribes. I will not maybe talk so much about biased AI and the Compass case that you all possibly know, that the data can be biased because the data, not the data, but the algorithm can be biased because the composers or the fathers, the human fathers of this algorithm could also be possibly biased. Recently, the Pretrial Justice Institute in US, who was defending very strongly of using the AI in, to launch the new prediction tools, now it says, let's hold our horses, let's analyze it more carefully, because there have been already quite a few discussions and also court cases. Okay, maybe this is not maybe, yeah. So being afraid of getting hacked, being afraid of getting heavily manipulated, this is also something that is that was maybe expressed by Estonian lawyers. When there was interesting research of whether they prefer the old-fashioned system with papers, or whether they should go to the electronic, let's say, to use the electronic tools, then there were some concerns that the electronic materials are somewhat harder to handle, even. Okay. So this is basically the classical example of the AI decisions. For example, the bank says that in a small city, let's say in Kaunas, people, possibly not, but okay, it's the case. Example that 80% of the people, they pay their bills late, and the bank doesn't give a loan to all of you, like people who live in Kaunas. Because it's a risk. Or there is another example of a boy who was, the young guy who was seeking for a job, and there was a questionnaire by AI and contained the questions of, have you ever seen the blood on the street? Have you ever seen the gun like 2 meters from you? The guy was born in a ghetto, but had a very good education, but it didn't matter. So we have to be very careful when, you know, the AI proposes some kind of solution based on whatsoever questions that look very smart, but in the end do not make sense. Restricted data, I think one of the problem in related to e-governance system in Estonia in general is that we don't have much data. So we cannot make a very deep decisions. We need more data. We have very interesting experience now. I'm going to the end soon. We are sharing the data with Finland now. This is an experiment that could be a pilot project for other countries. And it may also be in the judicial affairs, but currently it's in the field of medical affairs. Yes, sample size is important, and I would go on with some of the interesting cases, like the Siri landmark case, because now I think there is a big choice. Do we go to the standards, or we are discussing the values? I think there is a tendency that again, jurisdictions get divided. Like Germans, they say standards, and the rest of the world, or let's say France, says we have to look at the values when composing or constructing the algorithm and assessing the, let's say, accordancy of this algorithm to the rule of law. I would skip that now and come to the conclusion that the AI can be successfully used as creating agents in limited environment to replace some routine work of the lawyers, but it's the tendency. And I've been also expert for UNESCO now recently that artificial intelligence in natural environments, also like a legal society, is not welcomed, as we don't have a very clear ground for doing that. And of course, there is a marketing part. So if you wanna read some more information, there are few things, and the very first one is also published in cooperation with John here. So they are quite it must be Brill, not Brie, like a cheese or something. Yeah. And we are always ready to cooperate. So I hope that our cooperation with Vytautas Magnus, but also with other representatives of other universities will be even stronger. I would say thank you very much.
Yes, thank you very much, Tanel. You once again have proven that you are a great European expert on law and AI, I think, and I would say that the floor is now open for discussion. So please raise your questions, and Tanel will hopefully respond without any issues whatsoever.
Try.
Please.
Anyway, so one of the questions that I have is about this unboxing of the black box and explainable AI. So to what extent is it possible, particularly if we're talking about machine learning, deep neural networks, and that kind of thing that constantly evolve, and if we unboxed it once, then a short while after it would already have changed and be different, and maybe even those who had programmed the system would not be able to explain it anymore. And then the second thing is I really liked how you framed this sort of pseudo-objectivity of artificial intelligence, where we think that humans are biased and so on, but then it's the same humans coding AI, right? So biases do creep in, but then there's also the matter of training data. So what if training data represent biases, racial biases, sexual biases, and so on, that people of a certain group used to be convicted more often in the past, and that will reflect to people belonging to the same group in the future and kind of skew the results.
Yeah, maybe to start with the second question, that people are biased. I mean, we are all biased. We don't even maybe know that, yeah? The question is, I think the main concern is that if we are using the algorithm, we cannot maybe easily recognize that the algorithm is biased. And that's why what we suggest in our law school is the no legacy principle. It means that every algorithm should be, how to say, analyzed after a certain period of time, like after every year, to see what are the concerns to fix the problems. I mean, with human beings, it's somewhat easier to know the history of a person, what could be the possible biases, but with algorithm that is composed by anonymous, let's say, experts, it's harder. So I think the only solution is that we go back, we open it, we see what were the concerns, what were the disputes, and we try to fix it. It's also the other possibility is to use actually to invest more, which means that you have a tender for an AI system and you have different companies competing, and then you get more objective result. But of course, technically, yeah, I think this requires a lot of resources. But the unboxing thing, I think I would comment it so that Estonian government, very ambitious, full of very good people, some of them more skilled, some of not, but as always in every government, I think one of the main idea was to regulate AI with a law. I was given the task to elaborate the draft law for AI 2 years ago, and I said no, we cannot do it because we have a criminal law, we have administrative law, we have civil law, different terminology, different principles. We cannot put it all together. So what we actually did was we created a system of traffic lights. So we took all the areas of law and the main legal acts, and we said, okay, these laws should be changed, for sure, very few. So then yellow, this is like yes and no. I mean, there are pro and contra arguments. You decide, you are the policymaker. And the green, we said, no, you shouldn't change anything. It's like you have elections, and then you have e-elections. You shouldn't have two laws, but the principles should be the same. But then recently again, the Ministry of Justice, who seems to support more like value-based AI, and the Ministry of Economic Affairs, who supports the standards, you know, when setting up some AI. Basically, there was another attempt to adopt a general law, and there was an initial draft, like 80 pages long, and we were very critical. It was taken back again. So I mean, I also I asked, you know, why do you want to adopt a law that should be changed in 2 weeks, basically, because everything is changing, so we cannot really very specifically change the laws as the innovation is going on. And they said, this is because if we have a law, this is good for awareness for people. And I said, oh, it's not the cheapest way to do that, you know, let's do it differently. So I think, just to finish this part, I just wrote a project to the European Commission, and my concern is that I started with, when I started my presentation, that when planning the AI use cases, we are not following the good lawmaking principles. So basically, in ideal, we get the people together, we say, okay, we need this kind of AI because of, you know, less costs, more jobs for more intelligent skills people. We don't have it. We actually have a plan from the government to launch, again, 50 use cases for 2025 or something. nobody asks who initiated that, or why, or do we need that, or what's the cost, or where do we get, the innovation. So I think we should reshape this system and still have a, possibility to be included as a societal stakeholders, to say, okay, do we need it first, and then how it basically works. I think people cannot go into the details, but I also truly believe that that we have to invest to the education. It means that also in the kindergarten, also in the primary school, people should have some kind of introductory kind of education or training on what is the coding, or what you can do with data. And this seems a bit futuristic, but I think this is the future, that we have to mix different disciplines. So yes, we have to launch the new procedures also for let's say, playing with the new technology.
Lani, I think you're next.
Not sure if it's working, but thank you, Tanel, for such a wonderful talk. I was interested that lots of your examples seem to be focused on legal issues surrounding the application of AI, essentially. And I wanted to know whether that is a kind of reflection of the legal space as it currently is in Estonia or maybe in Europe, versus legislation around development of AI. And if that is the case, do you think there are reasons to move legislation towards development rather than application?
I believe that the future is actually related to both directions, that we should clarify what are the values and interpret them time to time. The values should be living, but also the standards. I think now we've been talking about ethical codes, and we identified actually what could be wrong, but we should also classify the AI. We should, I mean, everything is AI. You walk also in Kaunas, you see all these commercials, like every vacuum cleaner is AI, every car, I mean, the people do not understand actually what AI means and what are the categories of that. So I think we should also very much work with the standards and how to say, legalize them, so that I just give you one example. There are also political measures that can be taken. When I was working for the government office for the strategy, then we had, I think maybe less than 100, but a lot of meetings with every ministry, with every agency, to see what are the expectations with private companies, and what we proposed. I mean, the question is, how do we control AI? And what we proposed was the register. But then the private companies said, no, this is a burden, we don't want to be so visible there in the register and pay something. And okay, then we proposed the insurance, public insurance fund. I mean, it's not necessarily the law that regulates how to control the AI, but the insurance would be tool when there is a damage. The public funds pay the citizen or the company because it's unpredicted, it's unpredicted damage, and the private companies would possibly not take take actually this burden. I mean, the private insurance companies. So our idea was that let's compose a public fund. And as I said to the government, you don't invest so much on AI research, like okay, IT, yes, but not the legal, ethical. So let's put this money to insurance fund. And after 5 to 10 years, I don't know, maybe 5 years, you can sell the fund to the private companies. So this is now discussed, but I'm not sure it goes this way. I think we should be very careful when regulating AI. It's rather that I see there are certain principles that we can use and we can interpret. And interpret them in accordance with what the European Court says, what UNESCO says, what United Nations say. So this is living process, I guess. We cannot fix very much here, yeah. But maybe only with the standards. That would make a sense when we have a dispute over the AI. It was very vague, but yeah.
Any other questions or comments? Please use the opportunity to ask Tunnel.
I have to say you have this opportunity also later until the end of my life, so I'm available. So you can also send the emails and everything is there. Yeah.
Any other questions? So I put myself on the list as well. So I was very much interested when you talked about the AI judge. So that reminded me, at least to some extent, on a passage in Aristotle, in particular his Nicomachean Ethics, his ethical main writing, book 5, so chapter 5, when he talks about the notion of justice. And he says, if you go to the judge, you go to justice. And then the question pops up whether an AI judge could ever be someone or something that could be labeled as that. Namely, if you go to the AI judge, you go to justice. Okay? The question seems to be that if you judge, you see there are some certain problems, and Aristotle mentioned one problem which he called epieikeia, which means fairness. And he says the law there are a lot of cases, and the law is not always able to cover all cases. Therefore, you need epieikeia. Therefore, you need someone who determines, okay, the case cannot be the law cannot be applied in that case because it's special. So, would you think that we will ever see an AI judge that is also able to solve this issue? And I'm not talking about now the near future, but we are talking about 40, 50, 60, or even 100 years ahead of us. What is your view?
I very much hope that it will not be the case. I think in limited cases like these uncontested claims and maybe some administrative matters, this is possible, where you have very clear facts, very clear procedure, deadlines. This is possible. But even then, there must be a possibility to, the people have to know that it was a robot that made a decision, and then go and get a human explanation. This is for sure. But I think this has been a dream for many scholars to kind of argue that the machines or the algorithms are more precise. At the same time, I still believe that there is something that we call humanity that cannot be maybe defined, and maybe in this era, we can also revisit actually humanity to understand who we are in a way. So I think the algorithms should stay as assistants to the decision makers, who should have a clear choice and who should have a clear idea of how to alter the decisions offered by AI. And one concern that I have now is that, for example, judges, they are very busy. They have so many cases. They have such an information flow. It's awful. They actually even now say the AI proposed kind of structuring the documents is not sufficient, because they were actually better when working with the papers, because this AI doesn't actually know their personal kind of ideas of how to work with the information. It's very standardized and doesn't fit to all. So my dream is that if the AI is proposing a text or even the solutions, taking account the previous cases and taking account the so-called best practice, then there is also a time and space for the judge to look at the alternatives. It should be included to the system. Otherwise, it happens like in US with the Compass case, that everything is automatical. Judge doesn't have a time and just applies what the machine offers. So there must be, the draft, but it should remain a draft. The paper or the document or offer or solution actually composed by the AI. So there must be a space for human activity.
Thank you.
Okay, but thank you very much.
Any other questions? Any other
Maybe
questions?
I
Yes, please.
I'm Neringa Palonen from law faculty, and thank you for your presentation. It was quite interesting to listen news from this area. And listening to your report, one question arises. Like, there is an AI created for finding person who virtually sexually abuses children via internet. But still there are problems that these data collected by AI, they are not recognized as an evidence
Yeah.
in the court. What do you think? What are the main problems? Why still people and the court do not trust data collected by artificial intelligence?
Yeah, I have to admit I'm not a very good expert in the procedural law and evidences, but I think one of the problems of using the digital evidence in general, but also using the evidence that is collected not by human, is that there is no standard actually. I mean, again, there is some kind of black box behind, so it may be assumed by opponents that it was not objective or it was not in accordance with fair trial. So I think there must be also very clear definition and very clear frames for what kind of evidence can be used in which phase of the procedure. And currently I don't see that. I think also in Estonia the judge can decide basically which evidence is evidence in the terms of court proceedings. So I think we need more normative kind of approach here, and for the evidence, I think this can be really framed. Yeah, this is very vague answer, but I think there is a bit like chaos in this area, as there are many disputes also about what is digital evidence and who can present it and who produced that or reproduced that. So there must be also some kind of code or some kind of standard setting in the field.
questions? We still have some time. If you have any. Maybe one small question related to my previous one. So in one slide you mentioned that the AI passed the bar in the exam in Japan with a 9% better accuracy level. So that seems to be quite substantial. And then the question is, if you have levels like this, why not making use of AI in a much more substantial way with respect to sentencing, for example? That means on being a judge, an AI judge. If you see that they obviously are better at finding solutions, they have better access, much faster access to all the collected data on cases, so on and so forth. If we add that the decisions must be explainable to the person, so you press a button, so why do you think this and that is the case, and then the explanation pops up, so to speak. And if we can, at least to some extent, rule out a bias, machine bias for that matter. Mm-hmm. So would you then be more willing to to side for AI judges, or is that still something that you may want to rule out altogether? Because you were hesitating as well.
I think my answer would be still no, okay. because of very simple reason. When we are, I mean, about this case that the algorithm passed the PAR exam, but the algorithm knowledge was based on past. It means that how the PAR exam evaluated the candidates in past, what was the previous practice. And my concern is that the AI, I mean, we say, okay, thank you, algorithm, now you become a lawyer, but it would still, I think, keep the same track, trying to implement or use the knowledge that was very much framed, with a practice of past. So of course, algorithm is also self-learning, but taking account that they strongly were labeled with PAR exam requirements, and maybe also how the commission in that time evaluated the candidates. So it changes. And the attitudes are changing, and the society is changing. So I am afraid that AI could not at the same time be conservative and innovative, but this has to prefer certain let's say assumptions, and those assumptions in this case they are coming from, I don't know, this like 2000 to 2021, what was the practice of the Commission of PAR exam. So this is my naive presumption, but yeah.
Thank you. Yes, please, Julia.
Thank you for your presentation, first of all, and thank you for so insightful practical examples of the application of AI. My question would be, I would like you to prompt to elaborate probably a bit. You said that in order to make sure that AI is applied effectively, one would have to review it every now and again. So do you see that there would be a place for transparency, and do you think it would be possible? And what sort of transparency standards would you envisage in order to ensure that AI is actually being improved in a transparent way, and that it's that we can learn from bad experiences and good practices as well? Thank you.
Yes, I think this is very difficult question in a way. As I said, maybe we can apply the no legacy principle and go back, you know, not even when the problems appear, but just, you know, it would be a general rule that we have to open the box after a certain time period. But then how to prove that we got better for the citizens? I think it's only legal practice. If they see that there were certain threats for discrimination, then after applying the renewed AI or algorithm, we can just, you know, kind of screen if the practice would be different, or we maybe analyzed or changed or modified the wrong thing. So I think people could never get access to the black box inside of black box. I mean, the real thing. They could only given the information of how the thing works, like the data is coming here, which elements are screened, how they are, you know, how the AI is composing the, let's say, proposal or argument. But, you know, technically speaking, or the coding and everything, you know, this would remain still a secret, because it's also national security, it's also security of the state. Let's say if the superpowers, and now there is a question with quantum computing, of course, that, you know, if Russia, China, US, and whoever, or the new alliance, Great Britain and Australia, you know, they would afford, they can afford themselves a quantum computing system, then, you know, they have advantage, of course. So there are also interesting ideas in this field that quantum computers should be a common heritage of mankind. And I think this will not happen, that China will share, you know, please come, Micronesia and Polynesia, please use our, I think it's not possible. But yes, only the legal practice can then, I think, assess, you know, whether the AI is acting now better after new, let's say, how to call it, you know, after modification. Yes, basically the engineers say, and I work together with engineers, they say, okay, let's do the thing, because the engineers are not really interested of how fair or ethical, you know, the product is. They want to create something that really works and get the patent or get award or articles. So they don't really care. And we have to find this bridge between the engineers and decision makers or policy makers and the experts of law and ethics, and maybe economy also. I mean, how to understand each other. And this is, I think, the biggest challenge.
Maybe in the last 2 or 3 remaining minutes, going back to our main topic of the conference, legal education. And you mentioned one example with respect to, you know, let's say more senior judges and their skills with respect to the modern, the smart technologies and AI. What is your suggestion for the legal education with respect to the challenges that not only we as normal people face, but also the sector, the law sector, and people working in law? So how should the education be in the future?
Yes, I think it's very good question. As I suggested that, you know, all the people should get some kind of IT education, you know, from the very beginning. But when we are facing the current situation, then, for example, in the law firms, some of the law firms are really old-fashioned. You know, the guy comes and says, you know, I probably want to divorce, but, you know, also my neighbor is very bad, and, you know, very complex social issues. So this is all papers and discussion and maybe even cash, I don't know. But then, there are super innovative law firms that are having the startups. So there is also digital divide already. And this is social divide, because the poorer people go to the law firms that are operating in a very old-fashioned way, and they are cheaper. And this big bosses and private companies that are successful, they use the best opportunities, of course. So I think it is very much relevant to teach also the legal tech in the law schools. And I had this short chat with your dean, Professor Šalimas, who also indicated to that maybe the law schools are too orthodox nowadays. I mean, if you go to traditional law school, I don't know, in Europe, then you see that people are very much specialized, and if you say, okay, maybe you come to the project that relates to the whatever medical data, no, I have no idea of that. So I think the lawyers should also change, because the lawyers are serving the society, they are serving also whatever different areas, and they have to understand how to do it. And I think the problem with the law schools, majority of law schools, is that they want to keep the market as it has been, but they should actually instead follow the market that is emerging. And even better, they could be one of those stakeholders and one of the contributors to frame the new market. This is what we try to do in our law school. We are very tiny and small, but I think we need allies, and why not to compose a, let's say, association of, I don't know, innovative law schools, or to have a new legal theory or something against of conservative and very well established law schools that are losing actually the market. Also when talking about judges, there are judges of different age, and usually they are not too young. So they don't have these two thumbs, they still type differently. And I think the solution is that maybe they cannot be newly baptized, They have their own idea of how to do, but there must be a requirement that the assistants and the clerk of the court, they should be really IT educated. So they provide the judge, this AI-made, data sets, and the judge remains the judge and makes decisions, taking account all this information that can be processed more effectively. But maybe that's a too big, let's say, too big wish that judges who are, let's say, in 50s, maybe 60s, they would immediately become, very gadget-minded or digital-minded. So it's all about education. I think small countries as we are, okay, we are a bit smaller, and then we should. Maybe we cannot invest so much to innovation as such, technology, but then instead we should invest to the education.
Yes, thank you very much, Tanel, for your really excellent talk and the QI session. We will now have a 5-minute break, and then we will hear the next talk. Thank you.
Thank you again.
It's really great. Dear colleagues, our next talk is given by Ignas Kalpokas from LCC International University and also affiliated with VDU. He's associate professor and very much interested in political communication and digital things, so to speak. Julia Kalpokiene is the co-presenter. She's a PhD student at VDU, and her specialty is law. We will hear the talk. The title is "Who Will Teach Fortnite Law, Legal Education and the Coming Metaverse?" So 20 minutes presentation and 10-minute discussion. Please come to the floor. Okay, yeah, just as you like. You're not forced to.
Okay. So this is what an in-person conference looks like. Okay. Today, as we were introduced, we are going to talk about metaverse and Fortnite law and how this new emergent virtual environment, or at least an environment that has been predicted by pretty much every tech company in existence, how that is likely to change understanding not just of what is real, but also of the law itself. So, what does Fortnite have to do with it, and what does Mr. Mark on the far side has to do with it as well? Well, you may have heard in the news that Facebook is one of the sort of biggest tech companies trying their hand in creating the so-called metaverse, which is kind of an immersive digital environment. And it's facing tough competition. It's facing tough competition from already existing proto-metaverses, digital worlds, digital environments, and Fortnite is probably the best example of that, or the best established example of that, along with Roblox and several other platforms. So, how do we define the metaverse? Obviously, as it is a new and emerging thing, the definition is lacking, but mostly that relates to some kind of virtual realm that is being projected into the near future, where we can just put on our VR equipment and go wherever we want. We could move between different platforms. We could use a consistent identity, embodied, digitally embodied of course, by an avatar, and that would go with us everywhere we go. So there's a stable identity, and we just shift between different online experiences, virtual experiences. Some say it's going to replace the internet as we know it. So instead of browsing, we would maybe just visit different virtual places, again in 3D, and have fun there. Or some kind of melding of physical and digital environments, where something that you do in the virtual environment has effects in the physical space. Well, for example, you go to a virtual restaurant, you choose a meal, and then it gets instantly delivered to your doorstep. So there's integration there as well. Again, there are many different business models being proposed. But because of this sort of plurality of potential users, and of course because of the troves of data that is going to enable, because VR in particular is especially data generative, because you have all sorts of biometric data involved to make sure that the avatar moves the way you move and so on and so forth. So it's going to be the next big datafication tool as well. The metaverse really has become, therefore, the newest buzzword in Silicon Valley and related industries, increasingly, I would say, competing with AI as something that you always need to add to your business proposal in order to attract venture capital. And it offers not just data, it offers new markets, new ways of entering markets as well, new kinds of networking. I mean, we're already bored with Facebook, Twitter, TikTok, etc. We want something new, and why not have an immersive environment? And we're tired of 2D networking as well after the second year of the pandemic. So 3D would be a nice addition to that. But then in general, digital first life has been normalized. That's the way we've been living for the past 18 or 19 months already. So if we managed to adjust to that, well, a 3D virtual environment perhaps would be quite attractive in this sense. So what we are going to use it for, what at least the tech companies say we're going to use it for. Well, gaming, obviously. Gaming already is a big thing, and Fortnite and Roblox in particular, and you could add Minecraft again as one of the proto-metaverses. That's already what's being done. Working, that's very much the vision of Facebook, that they're going to build a virtual office. And so, in that sense, they're going to solve this problem where our bosses want us to be physically present in the office, but we just want to work from home in our pajamas all day long. Attending virtual parties and conferences, and concerts, well, conferences as well. You know, why not join your friends from around the world and have fun with them, or attend a concert? So thus far, the largest concert in the metaverse has attracted 12 million concurrent listeners. So there's no venue in the physical world that would be able to hold even a fraction of that number. Creating art. So NFT art is one of the new and emerging big things. And also, if you buy an NFT for 69 million, you want to display it somewhere. And if it's digital, you can't display it in a conventional gallery, so you can build one in the metaverse. Or just simply hanging out, having fun, and so on. But there are, of course, questions as to how it's going to play out practically. There are questions around monopolization or siloization of the metaverse, where we may end up in the end with either one big player controlling it all, or several walled environments that do not really communicate with each other that much. And if we think about how tech has developed to date, that seems like a fairly realistic scenario. And one of the really currently ongoing fights over this ability to actually transcend the siloization dimension is the core battle between Epic, the company behind Fortnite, and Apple, where it's still very much ongoing. So the first court decision has been in, and depending on whom you read, either this or that side has won. But I think one of the really important things is that Epic has managed to break through that Apple monopoly of just having their own app store and not allowing third-party apps in there, i.e. Epic's Fortnite. But there's some appeal process and so on. And in the meantime, Apple has banned Fortnite from all of its platforms. So it's really kind of dog-eat-dog at the moment. So, as I said, we already have examples of that, and those who or whose children are spending time on Fortnite and Roblox can certainly attend that these could be pretty attractive and to some extent maybe even addictive. And as I said, NFTs are also quite important in that. Not just because if you buy Beeples every day, so you want to display it somewhere, but also as a tool to actually kickstart a metaverse economy, because in order to have an operating economy, in order to, let's say, be able to sell and purchase digital goods, first of all, you have to introduce artificial scarcity, because digital goods are not scarce by definition. They're easily copyable. But if you can have this proof of ownership that, let's say, I own this digital Gucci bag and this is the original, then this definitely can help increase the price and kickstart some kind of financial flows within the platform. Because of the importance of the avatar and because of our desire to stand out and to connect with what we like in the physical environment, there are already interesting partnerships going on. So, for example, avatar skins are being made available, or avatar customizations are made available, let's say, from Marvel films, from sports. The Premier League has partnership with Fortnite, so you can have your avatar wear a Premier League football kit. And famous brands. So I didn't mention Gucci accidentally. So Gucci has had a very interesting foray into Roblox, and they released limited edition digital replicas of their goods. And at the moment, Gucci handbags on Roblox are selling for more than physical Gucci handbags in physical Gucci shops. So one has sold for over $4,000 US. So yeah, in order to have a good experience, though, we would need to have some kind of frictionless transition. I mean, those who have some experience with using VR goggles and choosing from the different things available through them, it's a laborious process. So we need kind of more smooth transition there. As I said, the avatar will be the central feature through which we interact with that environment. But then again, as Yulia will stress, the avatar is vulnerable or will be vulnerable, and that is something to keep in mind. A broad array of experiences is already present and will be even more so, but then content will raise challenges. So, for example, a few days ago, researchers uncovered that white supremacists were building replica concentration camps on Minecraft and using them for, enjoying their anti-Semitic ways. And an internal economy is going to be crucial because you want to monetize the metaverse somehow. The way in which you manage to actually earn money as a provider and as a brand affiliated with it, that's going to be worked out as well. So, yeah, user-generated content will be key. Roblox is already a pioneer in that. Brands will have new opportunities to connect and to sell their goods, and ones like Gucci are already doing that very successfully. And education. I think education is going to be one of the big uses of the metaverse, because it's not just kind of next generation Moodle and Teams combined. It's the ability to do stuff that we haven't been able to do during this pandemic. For example, to have hands-on learning, experiments, and so on in virtual reality. Say, virtual campuses. One of the leading Korean tech universities is already building a virtual campus in the metaverse and will be admitting students to that campus. So that's also something to consider. And now I give the floor to Yulia.
Hello, everyone. I'm very happy to be here in person today. Let's cherish the opportunity to actually engage in the physical environment until all this is substituted by avatars in the virtual reality, while our physical bodies are comfortably at home. And I must give credit for this avatar. It's my son's creation trying to portray me. Very accurate. So while much what we are talking about today may seem like too distant future, or things from a sci-fi movie, I encourage not to underestimate the speed at which technologies actually progress. Not long ago, artificial intelligence generated news articles or music seemed like a distant future or fruit of imagination, while today artificial intelligence generated creative content is hardly distinguishable or not distinguishable at all from the results of human creativity. And while many still engage in the discussions in respect to the possibility of computers deciding cases, as we've heard just previously, and engaging in the meting out of justice, in the US, for example, or in the UK, as it was mentioned previously, black box algorithms are routinely used to decide on one's sentence by determining the likelihood of reoffending. So Ignaz has painted the metaverse as an inciting and bright future ahead of us. And this may be the case, but you might have already gauged that I might muddy the waters a bit. I'm a lawyer by training, and I cannot overlook the risks, and hence I will engage in assessing the risks and dangers of the metaverse. So the regulation of the metaverse has added challenges compared to those of regulating the internet or cyberspace. In terms of the internet, we have those traditional challenges that we talk about, is borderless nature and perpetrators' ability to reach people instantly and reach lots of people or lots of victims instantly, and also anonymity and adds on to that. This all is valid for the metaverse too. However, as the promises of an all-immersive and highly anonymous space, with the prospect of being able to actually wear a suit, enabling one to get essential experience as well in the virtual reality, with avatars being suited, booted, and accessorized in whatever one pleases, including designer bags and accessories, as we heard just before, with views, sounds, music, and so on being generated for different environments within the metaverse, with the ability to transfer oneself from one space to another potentially, and similarly to how we currently navigate between one website to another. So regulatory challenges that instantly spring to mind, just to name a few, are those of copyright, for example, and trademark infringements, because you want to have this immersive environment where you listen to some music, you have designer bags and so on, and also endless opportunities for criminal activities too, and the risks of sexual exploitation, grooming, and so on, also including radicalization, and yet another environment for spread of mis and disinformation. And that is not all. Similarly to what we've experienced in the past with the colonial rule, there are suggestions that now this hardly inhabited metasphere and yet unregulated space is being colonized by the big tech companies, by the big players, and they are the ones that will shape how it is regulated and how things are done in the metaverse. So at the broadest level, the exact nature of governance in the metasphere is yet to be determined, and much will depend on the way in which it is going to develop, primarily whether it is going to evolve in a decentralized manner or be an oligopoly or several major players
For example, we could predict that Facebook, Alphabet, Apple, Amazon, and other big players will try to engage in the development of metaverse and use it to their advantage and will monetize it. Nevertheless, given the current discussions around regulating social media platforms, and other large technology companies, and potentially even suggestions to break them up, one can anticipate that such suggestions may come in respect to metaverse as well. And also the aspects of self-regulation and setting standards will be important as well. And I think that it is likely that we will see in the future suggestions from at least some players in some countries going towards data localization. And this could happen in terms of metaverse as well. But it is suggested that for now, regardless of how it's going to develop, it is likely to be a playground for private companies. And then we can move on to another aspect, which is worrying. And as Ignas mentioned, metaverse requires lots of data. So while historically mass surveillance tended to be associated primarily with undemocratic regimes, nowadays, especially after the leaks by Snowden, mass surveillance is no longer reserved to a small pool of actors. And so we can anticipate that there will be database discrimination. One may argue it is not only an issue in countries such as China with its points-based social credit system, but also on major digital platforms when the search results, for example, are displayed according to the data that has been collected about the user. And also, because of the immersive nature of the metaverse, this virtual environment means that human behavior there is likely to be more authentic and reminiscent of the real life. For example, if you compare it with simple browsing, you will collect more data when someone immerses into this metaverse. And since data is collected, shared, sold, and inevitably hacked, as it is suggested, it will be the case. Well, we have examples now in respect to data leaks. And there is near unavoidability that it will be weaponized by those seeking of profit or seek new ways to hurt, and mundane by ruthless advertisers, hateful trolls, and malicious state actors. So with virtual reality, it is based on the need to constantly scan the environment. So it's not only the user that is being scanned, but it's also everything around. So there will be lots of people that can't actually agree to their data being collected. So there will be lots of data issues, and because we are short on time, so who will be the trailblazers in regulating the metaverse? Well, as we know, states tend to be slow in adopting regulation, and it's been suggested so far that sometimes it's not the best idea to regulate everything by drafting new legislation. So self-regulation will be important, as well as policy, industry standards, and also existing laws, because we will see, as mentioned before, things as copyright infringements, trademark, IP rights infringements, and so on. But also it's important to have in mind that people, and especially younger people and vulnerable people, are enticed into this metaverse, and they're more vulnerable, so they need to be protected. And it will be important that criminal enforcement agencies have the competences and the ability to actually protect those. Yes, and that's then. I thank you and welcome any questions you may have.
Thank you very much for this very interesting presentation. So, please, questions, comments? Yes, please, Adrienne.
This microphone is not working, but I'll try to be loud. Actually, I loved your presentation because Fortnite, when I saw the Fortnite blog, right away I thought about my two boys, and I was thinking that the Fortnite is one of those rare things that actually that my children never forget to turn on during the day. And it would be really a great idea to introduce some learning aspects into Fortnite, so I think that then I would never have to convince them to get up in the morning and go to school. So it really sounds very, very interesting, and it would be really great, but also on the other hand, it sounds very, very risky. And I was thinking that my question was, do you think that that real law and let's say accountability, responsibility, and the punishment system should also be introduced into metaverse, or do you think that this would then make all these games and metaverse not interesting anymore? And another thing that I was thinking about was, should we then also start teaching aspects of legal responsibility to our children already now at this stage as part of their school curricular, as in metaverse they already are doing all these crimes like IP infringements, using all these weapons to kill. So do you think that maybe this future of legal studies must start now at schools already?
Well, I will start with the last part of the question, and I'm an advocate for legal education being integrated from a very early stage, and I made a point last year to go to, actually 2 years ago when COVID situation permitted to actually do it, went to the preschool class of my son, and actually we spoke about law and how it is, how it kind of operates in real life, and did some negotiations and even drafting activities in a fun and engaging way. And I think that is important, that not only kids and students and pupils are taught about law, but also teachers and educators, first and foremost, have to have this general understanding of the basic legal principles and also about this digital environment that they engage with daily. And I think that it's important that people are educated, because this has never been part of the curriculum, for example, when preparing teachers and so on. So I think it's very important. And I feel that things like intellectual property law, data and protection and privacy matters are very important to be integrated in the curriculum, because in terms of criminal law, many understand what it is. Like, you have this common sense, or you can pick it up from films and so on. So it's important to highlight that in the digital environment, it's not different. So if you like, we will have to kind of, as a society, come and define, is it equivalent to kill someone in metaverse as it is in real life? And I think it's some moral judgments that we, and moral questions that we have to answer. But it's important to convey to people that if you belittle someone, or if you say nasty things to people online, it's not lesser evil than face to face.
Okay.
Yes, Tano.
I also said about that there are many new phenomena in the world, and I think GDPR was the first kind of attempt to fight against of something that would be really a threat to European Union. Some see it as a protectionist, legal act, and now we adopted or are adopting also new big legal acts. What do you think in metaverse as a phenomenon? Does it need a new big legal regulation? As you know, it's very complex. You have IP, you have privacy, or it would be kind of understood and you know, kind of screened and analyzed through the GDPR and through the Data Markets Act, and you know, would it create a need for rethinking everything that we have and create a special legal act for that? And maybe another question is, as a metaverse, I think this is like universal. It cannot be really state level or regional. So how do you see that from legal point of view? I mean, who should be the regulator then?
Yeah, I think that, you know, in terms of a new piece of legislation specifically for that, I can't foresee that, because as it is universal, it's difficult to envisage that something effective could be agreed upon and drafted. But then, for example, if we look at GDPR, it could be applied to, like it is applied in cyberspace, so why not apply it in metaverse? But also, I think it will be a combination of both, because we have very good industry examples. For example, when we look at DNS abuses and technical abuse and action at the DNS level, it's not really regulated by states, but it functions quite well. And TLDs, CCTLDs are quite good at actually addressing those issues and dealing with that. And they actually work on setting standards and actually addressing the issues that happen. Same with botnets and things like that. And although you don't have, this issue transcend the borders of states, we don't really have national legislation in respect to that, but it's still effectively tackled. So I think we will see a combination of both, but the issue of jurisdiction will be there, that's for sure, and something that has to be addressed, but it has to be addressed in respect to cyberspace and the internet as well, because there are quite a lot of issues that can't be resolved, and we can see trends in data localization in some instances, and that doesn't really aid. And yeah, so those are problems that can be discussed long, but there are currently no solutions to that.
Although I would kind of partly add that universality is not necessarily a given, provided that already where the current internet, we do have examples of states trying to go their own way. And China has always been an example that's often talked about, with their attempts to filter content, block certain parts of the internet and so on. Countries like Russia building their own versions of the internet that can, in theory at least, operate without being connected to the broader internet and so on. So I think we shouldn't take universality as a given. It is likely that universality will prevail, but I think we should be slightly cautious about taking it as absolutely natural.
Since we are already past our time, but one final question, a quick question I have, also related to the main topic, legal education. Would you think that the development of the metaverse requires a new type of lawyer, let's put it this way, maybe the metaverse lawyer who deals with, you mentioned already virtual immoral acts, but also, digital rape, harassment, bullying, that have also real-life consequences with respect to suicides, for example? Or is it also an issue stealing the digital Gucci bag? I don't know whether it's possible, but questions like these, do we have to have a particular way of educating our current lawyers and to make them fit in order to deal with this metaverse universe, so to speak?
I think that, it's always said that lawyers have to think outside the box. So if one is able to do that and is tech savvy and interested in whatever is happening around them, then you have a lawyer that is able to adapt. And I no doubt will adapt to metaverse as well. So is then the question whether our education system is fit for that, whether we actually are able to prepare those engaging and critically thinking young individuals that are able to find innovative solutions and have their own opinion that they can substantiate.
Yeah, and also I think something that we need to work on is the very understanding that virtual crimes are real crimes in the first place, because there seems to be quite a lot of resistance to acknowledging that something that happens in a virtual environment actually has physical ramifications as well, or that something that's purely digital and purely synthetic in its nature can have the same consequences as something that relates to, let's say, the person's own body. One example could be deepfake revenge pornography. So we increasingly have laws that prohibit the deepfake revenge pornography. So we increasingly have laws that prohibit the creation and distribution of so-called revenge porn when the real person is involved. But when you just add a person's face to pornographic content, because it's not their own bodies, it's just part of that person, it's usually not seen as a criminal activity. And there's only a handful of places where processes are being put in place to actually persecute perpetrators who create deepfake synthetic pornography.
But that's a policy matter, so that's what the politicians to actually decide. But I think, like, there are different lawyers, and even nowadays we still have lawyers that write procedural documents with a typewriter. So this type of lawyers will definitely not, well, I think they will not adapt to the metaverse, and they will not want to work in that space. But I think that young lawyers are quite adaptable.
Thank you so much. Great talk. Great discussion. Our next speaker is Lani Watson from the University of Oxford, UK. She has a PhD in philosophy, right? In philosophy, yes. And so she's specialized in how to ask the right questions, which is an interesting field, of course. And her topic today is epistemic rights in the information age. Lani, the floor is yours.
Okay, I just need to find, here we go. Excellent. Well, thanks very much for having me here. It's a joy to be here in person and not in the metaverse yet, which I'm nervous about. I'm going to be talking about epistemic rights in the information age. And the talk is based on some of the content in my recent book, so I'll just get that plug out of the way first. It's called The Right to Know, Epistemic Rights and Why We Need Them. Okay, so we speak of the right to know with relative ease. You have the right to know the results of a medical test or to be informed about the collection and use of personal data. And these rights, which I call epistemic rights, are increasingly prevalent in legal settings and on the international stage. And they've come to the fore in part as a result of harms and wrongs that have been made possible by the advent of new and increasingly sophisticated technologies. But my question is what exactly is the right to know and who should we be trusting to safeguard it. So in this talk, I'm seeking to illuminate the concept epistemic rights. And I think that these rights play an increasingly prominent role in our lives and communities, yet often go unnoticed, disregarded, and unprotected. So by illuminating this concept, I seek to draw attention to epistemic rights as a distinct and unified class of rights. So in the book, I argue that epistemic rights can and should play a central role in the legal education of the future within the information-centric world that we identify as the information age. In this world, those who control what we know or think we know exert an influence on our lives that is often as dangerous as it is imperceptible. So understanding the nature and scope of epistemic rights as both legal and moral rights, and recognizing the harms caused by their violation is, I believe, an increasingly important aspect of the contemporary moral and legal landscape. So what exactly are epistemic rights? Well, in simple terms, see if that works. Epistemic rights are rights to epistemic goods such as information, knowledge, understanding, and truth. So the right to know is one such right, as is the right to be informed, to understand, and to the truth. Crucially, epistemic rights are, first and foremost, a form of rights. They are as substantive as any other rights, such as workers' rights, children's rights, or property rights. And the difference lies only in the content or subject of the rights. So property rights concern property, while epistemic rights concern epistemic goods. So just as you have the right to rights regarding your mobile phone, so you have rights, or in fact don't have rights, regarding the data on it. The former is a property right because it concerns property. The latter is an epistemic right because it concerns an epistemic good. So that's a simple explanation. The more technical definition: an epistemic right is a complex entitlement that provides justification for the performance and prohibition of actions and omissions concerning epistemic goods. So in the book, I go over an analysis in detail of that definition, which comprises the structure, the function, and the justification of epistemic rights. Obviously, I don't have time for all that here, so I just want to draw out two central elements. Firstly, a right is a complex entitlement, meaning that it's structured by four senses of the term right, which is probably familiar, originally identified by the legal philosopher Wesley Hofeld. And these are privileges, claims, powers, and immunities. So to understand how that Hofeldian structure translates to the epistemic domain, I'll just use a quick example. So imagine that I'm being tested for diabetes by my doctor. Once I've been tested, I've got a privilege right to know my blood sugar levels, which means that I've got no duty not to know them. I also have a claim right to know my blood sugar levels, meaning, for example, that I have a right to prevent my doctor from misinforming me about them, and that my doctor has a duty to provide me with accurate results. And in addition, I have a power right to waive my claim right and thereby not to know my blood sugar levels. And finally, I have an immunity right, which protects me from my doctor taking away or altering my claim right to know my blood sugar levels. So those four senses comprise the complex entitlement that I have regarding my blood sugar levels after being tested for diabetes, and that's my epistemic right regarding the information. I follow Hofeld's lead and am most interested in the aspect of this entitlement that is epistemic claim rights. And that's because of the relationship between claim rights and duties that I will return to in a bit. So secondly, the function of epistemic rights is to mandate actions and omissions concerning epistemic goods, more precisely the performance and prohibition of actions and omissions. So doing this, epistemic rights protect epistemic right holders. And in essence, this answers the question, what do epistemic rights actually do? It means, for example, in the case of the diabetes test, that my right to know my blood sugar levels, when it's taken as a claim right, translates to a duty on the part of my doctor to provide me with the accurate test results. Put simply, it means that epistemic rights affect what we can and cannot do. This is an important feature of the analysis. So think again of the rights you have regarding your mobile phone. These are not, in essence, rights to the phone itself, the physical object. Rather, they're rights to determine what you and others can or cannot do with the phone, such as making a call or sending an email. So I can't rightfully make a call or send an email on your phone without your permission, precisely because it's your phone, and you therefore have the right to determine what I do with it. And the same is true in the case of epistemic rights. The rights you have, or again don't have, regarding the data on your phone are not in essence rights to that data itself. They're rights to determine what you and others can or cannot do with that data. So recognizing that rights pertain to actions and omissions is an important step towards understanding their significance in our moral landscape. Okay, so that's what an epistemic right is. Epistemic rights protect and govern the quality, distribution, and accessibility of epistemic goods. So where do we find these? First of all, we find epistemic rights in ordinary language talk. We speak of the right to know and the right to be informed about everything from the ingredients in the food we eat and the products we buy, to the conditions of our employment, the terms of our mortgage loan, our children's education, the interest rates our bank is charging, and so on. You have a right to know how much money you have in your bank account, a right to understand the details of a legal contract that you sign, and the right not to incriminate yourself in a court of law. So while the term epistemic rights is not yet widely used, talk of epistemic rights is commonplace. David Cody, in a 2010 paper, articulates this well. He says, "It seems clear that our ordinary thought about rights includes this concept, as when we say, for example, that a patient has a right to know his or her medical condition, a soldier has a right to know the cause for which he or she is fighting, or that the public has the right to know about some of the activities of certain public figures." So these epistemic rights find easy expression in ordinary language, and they're a mix of privilege, claim, power, and immunity rights. We also find these rights in legal and political settings. So take, for example, rights to the protection of personal data, Article 8 of the Charter of Fundamental Rights of the European Union, right to access information in public records, protected by freedom of information laws, rights to own intellectual property, protected, for example, by the TRIPS Agreement, and finally, the UN's Universal Declaration of Human Rights and the expanded International Bill of Human Rights contain a number of epistemic rights. In particular, Article 19, which says, "Everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers." So we'll return to that in a moment. But I think the inclusion of epistemic rights in these contexts speaks to their non-trivial role in international political and legal settings, and to their treatment as a robust and substantial form of rights. Nonetheless, the technology-dominated, information-centric world in which we live is changing fast and not always for the better. And as such, the need to identify and legally safeguard an increasingly diverse and widespread suite of epistemic rights for both individuals and society at large is, I think, increasingly complex and urgent. So a first and basic issue concerns who exactly has epistemic rights in any given case. Not all right holders have the same epistemic rights. I have the right to know my blood sugar levels after being tested for diabetes, and you don't necessarily have the right to know them. So the allocation of particular epistemic rights to particular individuals is going to determine on lots of different things, like all other rights. It's conditional on certain things such as who, when, and where the right holder is. So for any individual, the possible sets of circumstances are going to be vast. And I think, therefore, the task is not to assess every individual set of circumstances, but to come up with a general heuristic or rule that can be applied to all cases. So a rule for the allocation of epistemic rights. So I offer the following general rule. A right holder has an epistemic right when it is legally and or morally permissible to enforce an epistemic duty. That rule gives us a way of determining who in particular has an epistemic claim right to what. And moreover, this rule applies specifically to claim rights. As a result, it tells us that epistemic duties are integral to the allocation of epistemic rights. So what exactly are epistemic duties? Again, simply put, an epistemic duty is a duty that concerns epistemic goods, a mirroring essentially of the simple version of the account of epistemic rights. So think of the duties that others have not to look at your text messages without your permission, or the duty that my doctor has to provide accurate information about my blood sugar levels. And we can add substance to the notion of an epistemic duty by looking at different types of epistemic duty. So I draw a inspiration for a basic taxonomy of epistemic duties from Article 19 that we just looked at. Everyone has the right to freedom of opinion and expression. So Article 19 is typically cited as the article that concerns freedom of expression, which of course it is, but the article covers more than a person's right to free expression. In fact, it covers a person's right to seek, receive, and impart information. And I think these epistemic rights correlate with a basic taxonomy of epistemic duties, duties to seek, receive, and impart epistemic goods. That's a basic taxonomy because I think it can be built out significantly, but I think it provides us with a fundamental frame around which we can build a more complex taxonomy. Indeed, we can start by doubling the three basic epistemic rights by noticing that they each comprise both a positive and a negative component. So epistemic duties to seek epistemic goods and not to seek epistemic goods, and the same for receive and impart. So we can see that taxonomy at work in the case of my right to know my blood sugar levels. My doctor has a duty to seek, collect, acquire, find out the test results. He also has a duty to receive, listen, hear, accept the test results as reported to him. He has a duty to impart, tell, give, explain the test results to me. He also has a negative duty not to, for example, seek out irrelevant personal information about me, receive that information, or impart irrelevant personal information about someone else to me. So those are the 6 types of epistemic duties. Okay, so where and how should epistemic rights feature in the future of legal education? It's the tight correlation between epistemic rights and epistemic duties that I think perhaps underlines most clearly the role of the epistemic rights framework in the future of legal education. So recall the general rule for allocating epistemic rights. A right holder has an epistemic right when it's legally and or morally permissible to enforce an epistemic duty. So epistemic duties are integral to the allocation of epistemic rights, and in particular directed duties, which are duties owed to a particular right holder. They're the necessary counterpart of the Hoffeldian claim rights. So these duties, as Rowan Kraft puts it, are at the heart of rights. So we can't determine the allocation of epistemic claim rights without determining the relevant duty bearers. We can't determine when it's legally and or morally permissible to enforce an epistemic duty without identifying the individual or institution that must discharge the duty if required. Onora O'Neill has compellingly emphasized the significance of this tight correlation between rights and duties, and she's argued that it poses a particular challenge for advocates of universal human rights to goods and services such as food and healthcare. Crucially, she stresses, we cannot tell who violates a right to goods or services unless obligations have been allocated. And that's true for epistemic rights. Think of the right to education. For example, Article 26 of the International Bill. Accordingly, all of us have the right to education, but we don't all bear the correlative duty to educate. So you don't have a duty to teach me about the metaverse, although thank you for doing so, any more than I have a duty to teach my next-door neighbour epistemology. Such duties, where they arise, must be allocated to particular individuals. So, as Anil puts it, rights must have well-specified counterpart obligations. So, return to Article 19 for the last time. I've built a taxonomy of epistemic duties on the foundation of this right, and yet it's still unclear to me who the relevant duty bearers are in this particular case. Everyone has the right to express ideas and opinions, but who is responsible for safeguarding this right, and how can it be legally protected in the fast-paced, deeply interconnected, and information-centric world? Is it the responsibility of national governments, international bodies, traditional media outlets, social media companies, or is it in the hands of individual citizens to take care of their own and their others' epistemic rights? These questions and many others, I think, are critical questions for legal scholars working in this kind of field. And they are starting to gain attention on the international stage in light of the new and more widespread harms that have been made possible by the rapid technological advancement of the past 20, 30 years. So our final comment with just one example of this, the Schwane Principles on National Security and the Right to Information that were developed in 2013 as a collaboration between 22 different organizations and institutions based on international and regional laws and standards. They were developed largely in response to the leaking of top-secret National Security Agency files detailing the vast system of global surveillance that we've all become very aware of, exposed by Edward Snowden. So Principle 10E, for example, states that the public has a right to know about systems of surveillance and the procedures for authorizing them. And Principle 4 identifies the relevant duty bearer. It's up to the government to provide the necessity, to prove the necessity of restrictions on the right to information. So the Schwane Principles go some way towards answering the complex questions such as who does or does not have the right to conduct large-scale covert surveillance activities on the general population, whether or you have a right to know about it if someone is tapping our phone call or monitoring our emails, who is responsible for ensuring that our epistemic rights in this regard are not violated. I think that's a promising start, but the Schwane Principles are not laws in themselves, they're just guidelines, so they don't provide any concrete legal protection of the public's right to know about systems of global surveillance. And I think surely protection is warranted. This is precisely the type of place where I think legal scholars can, I hope, put the epistemic rights framework into action. We still lack the conceptual resources and the vocabulary to make sense of and articulate the information age, including many of the new and more widespread harms that have been made possible by its advent. And I think that treating epistemic rights as a distinct and unified class of rights gives us one small piece of the conceptual puzzle that can and should play a role in articulating and addressing these harms, and thus an important part of the moral and legal landscape of the future. Thank you.
Yes, many thanks for this really insightful talk. So, any questions, comments? Yes, please.
Thank you. It was a very interesting presentation. And I was in particular interested in this part when you mentioned about the right to information and the right to understand. I think it's just to get information is one thing, but then as you mentioned the doctor, I can imagine that for a just random person who is not a professional in the field might be difficult to understand information. And in legal area, we also have this discussion about that legal text should also be understood for just non-professionals, non-lawyers, and that the court decisions, for example, they have to be understood for non-professionals. And then the question might arise, because in the court decisions or in the legal text, you have to use certain legal terminology. You cannot avoid it because then the text might be just oversimplified. So the question would be, what would be the scope or the extent of this epistemic duty, for example, to provide information that it is understandable?
Yeah, I mean, I think that's such a good question, and it's a incredibly complex, you know, as you are quite rightly identifying, question to try and answer. One of my early kind of back and forths when I was thinking about this concept and writing the book was whether or not to call these epistemic rights or information rights, and lots of people were in favor of information rights because there's a view that these rights can be just reduced to the exchange of information. And also information is just an easier word to hear and than epistemic. But I ended up having to call them epistemic rights precisely because I think particularly the right to understand is going to feature in this landscape, and it's important that we don't reduce that merely to the exchange of information, but that we make it understandable information. So I think the cases that you're raising, the doctor case and the kind of legalese case, are really important ones, precisely for the reasons that you've identified. I think there's going to be a lot of questions to answer around exactly where, because, to what extent is it someone else's capacity that matters, and to what extent is it the kind of ability of a lawyer or a doctor to communicate in an understandable way. There's going to be lots of grey areas, I guess, in decision making, but certainly we need to have the right to understand. One place where weirdly it's in existence in the UK is there was a huge scam about a decade ago, I think, around PPI, payment protection insurance. And it was basically banks that were selling loans and they were adding to that an extra payment protection insurance, but without really explaining to consumers what they were paying for in that case. And then there was a huge kind of backlash to that. Ultimately, it went to the Financial Regulation Authority, and finally, all sorts of laws have come into effect in order to prevent the mis-selling of PPI. But really, it revolves around mis-selling as a result of failing to explain properly what the product actually is and what it's doing. And so now there is a requirement that the bank gets the customer into a position where they understand what they're buying. I don't think that we have epistemologists need to get on that, because I don't think we have a very clear sense of what exactly that entails. But it's interesting that these laws are being made reflecting understanding, not just information. And then just also to bring it back to the kind of tech space, of course, explainable AI and black box issues are going to be crucial here. And it seems to me we can't just have a situation where coders and engineers and developers can send, Tanel a bunch of incomprehensible engineering and developing language. He needs to be in a position to be able to understand that language, and as do we all when those kinds of algorithmic decisions are being made. So I really want the right to understand to feature. I want to champion it. I'm not sure if I can go much further than advocating for it at this point. But thanks for your question.
Yes, Sam, please.
Maybe just to extend it a bit, it's like with the human rights, you have a certain civil and political rights that the government is responsible for, but then you have also social and cultural rights that, they are not so much protected, like the right to the work. I mean, the government is not actually obliged to give you a work. They are obliged to not to discriminate you when you apply. And I think there is maybe some kind of similarity when we are talking about if someone is responsible for explaining? And what is the effort you have to make? I mean, if the client, or addressee says, okay, I understood, but we understand that he or she didn't actually. I mean, the question is, if we are using AI for, let's say, medical solution is there, the doctor says, okay, there is medical solution, but it was somehow composed with the help of AI or, different technologies and, some kind of using metadata or, so my question is, what is this explainability still? Is it like to explain the procedure or the need or the consequence, or how do you define this explainability?
Yeah, I mean, exactly. I mean, that's a really important question. I guess my kind of angle on this is to try to force the issue legally, that force it to be the case that we need to answer that, find a way of answering that question, basically, by legislating. The example I gave of the PPI maybe doesn't really, maybe it speaks against this approach, because it seems like we've gone ahead and legislated that the customer has to understand the product without necessarily answering that question. I guess my hope is that, particularly in this very new, innovative kind of space, where we're all trying to figure out what are the right ways to regulate and legislate tech development and application, that if we insert the notion of the right to understand the algorithmic decision-making process, then we can at least force the issue of finding ways to answer exactly the question that you're asking. I mean, in terms of what it looks like, I think, as you've kind of hinted in your, or very strongly suggested, not hinted, in your talk, education is going to be absolutely vital to this whole puzzle. And I think that if we have education, quite as you suggest, at a very young age in the tech space, then we might be in a much better position to find the right way to answer this question, because it's one thing to try to explain to, a 95-year-old, grandparent or whoever that their bank loan isn't going to be approved because computer says no algorithm, and nobody has any accountability for how that answer's going. There's no way that that person is ever going to be able to understand the answer, even if they did. If we can educate right at the very young age people to at least have basic technical concepts like coding and engineering, then maybe we have a chance of getting into a position where we know what it means for someone to understand it, and it's a reasonable expectation that they do. Yeah.
So you also think that there is an obligation to educate?
Yes, very much so, yes.
Yes, unfortunately the time is up. Thank you so much for your talk, for the discussion. We will have now 1 hour break. We will reconvene at 1:10 for the second half of the conference. We will be able to enjoy some snacks on the side, coffee, and yes, see you later. Thank you.
Thank you.
So, dear colleagues, it's a pleasure to see most of you again. I know that many of our colleagues are following online. Nonetheless, we will continue the second to start our conference, or to continue our conference, and start with the second part of the conference. And it is a great pleasure to introduce briefly our second keynote speaker, which is Ephraim Nissan, who is affiliated with the Goldsmith College, University of London. And he has been working in the field for several decades and is a well-known international expert. And I'm very happy to have him speaking about a very important topic, as I think, using computing in the construction of proof in criminal cases. So Ephraim, it's a pleasure to have you here. The floor is yours, maybe 30, 40 minutes, and then it will be followed by a discussion of 20 minutes, 30 minutes, something like this. Thank you.
Okay, so my talk is about information technology, and in particular, artificial intelligence methods in the service of legal evidence. The next slide, please. Next slide, please. Can we have the next? Yes. Some kinds of application, it's not an exhaustive list, is that there are, for example, network models for police investigation that we are going to see what they are. There are tools for jurisdictions based on the Napoleonic Code, such as Daedalus for the examining magistrate in Italy, who becomes then the prosecutor. It is important for them to validate step by step all steps taken by the magistrate, and then in order also to document what was done so that the police behaved correctly according to the orders of the examining magistrate. Then there are narrow scope models for police investigation. There are models for several particular forensic sciences. There are AI models that are specifically devoted to just the reasoning about the evidence. Then there are, especially in the United States, jury dynamics models of how the jurors change opinion. And then there are models of how to organize the argumentation. Can we have the next slide, please? Next slide, please. Can somebody get the next? Yes, thank you. Tools for the police. There are tools for allocating police presence, and they may be related to geography, such as a geosimulator. One of them is called ExpertCop. And this is for the purpose of preventing crime. But there also exist geographic tools for members of the public. In Bangladesh, there is the Protobody tool for reducing street harassment. It sounds an alarm, it sends text messages to emergency contacts, and then the incident data are collated so that the police could have a heat map showing which areas there is more harassment. Can we get the next slide, please? Yes. there are tools that, because of their kind of computer architecture, are called multi-agent systems. Such is the case of the Cactus system. A multi-agent architecture in the 70s and 80s would have been considered part of artificial intelligence. Now it is not. But it delegates subtasks to components which each have their domain of expertise. For example, Cactus, in order to train the police in managing public order events. And for example, let us see the very first multi-agent system. It was called a Blackboard system. There is a global problem to be solved cooperatively by pieces of software. They are written on a blackboard, and the agents are asked which knowledge source, or called also agent, can solve it. Every agent, if it needs help with a subproblem, it also writes this on the blackboard in order to get help from other knowledge sources. Can we have the next slide, please? Yes. In 2012, I published a bulky book in 2 volumes, Computer Applications for Handling Legal Evidence, Police Investigation, and Case Argumentation. It was published by Springer. And well, whereas printed copy in hardback also sold, there have been over 10,000 downloads of chapters from the database of Springer. Can we have the next slide, please? The police in Great Britain, they use the police national computer. They sometimes, police station use some software for the identity parade. And then there is Flints developed in the West Midlands by a former policeman, Richard Leary, for the criminal intelligence analysis done by the police. And also it has a graphic interface in order to link suspects in a network link analysis. And then there are several tools for the forensic science. For example, there is a pollen database for an analysis of the pollen, according to which you can trace the territory from which the pollen arrives on the garments, for example. There is forensic geology. There are several electronic tools, chemistry tools, for example, for narcotics, face reconstruction from skulls in animation, and so forth. Can I have this next slide, please? Next slide. Yes. Yes, Flints has had data, for example, DNA, fingerprints, footprints, and soft data, which have the behavior of the suspects. And a later version also does geographic profiling. And next slide, please. Yes, there are unknown offenders that have to be identified. There are links that have to be detected, and the expansion to other police areas, volume of crimes, and the volume of suspects, the population of the suspect, and also forensic decision making, and asking questions about people and suspects or about crimes and events. Next slide, please. And also, there are charts of argumentation called Wigmore charts, and there is a temporal analysis, a geographical analysis, and to find who are the prolific offenders, and searching in vehicles, cars, and audit trails. Next slide, please. Yes. Now, apart from tools for examining social networks, there are also tools that resort to data mining in artificial intelligence. And there are tools that also, apart from trying to link geography and social links, there are also textual interconnections. The best known example is the scandal of Enron Corporation, when the Enron email database was mined by artificial intelligence tools in order to discover connections. And then the database was put online for researchers to use it in other projects. There are tools such as sites for text mining that discover social coalitions through those texts. There are tools of data warehousing, that is very large databases, legal ontologies, which are networks of concepts in law, and also in financial fraud. Can we have the next slide, please? Examples of tools for crime detections are NetProbe for internet auction fraud, Polonium, which does data mining on graphs in order to detect malware detections, that is harmful software. There's link analysis for the police with Coplink. There is a project for the United Federal Defense Financial Accounting Service, and such tools. For example, a fiscal fraud detection in Pisa through the Sniper project. In Poznan in Poland, there is also a model for the link analysis of fuel fraud. So it is specialized in a kind of fraud. Can we have the next slide, please? Yes. And then the specific forensic disciplines. There are AI tools for crime scenario modeling once a dead body is found. There are face recognition methods. Also, when a child has gone missing, there is software that would reconstruct how that child would look some years later. There is facial expression recognition and, for example, reconstructing the face from skeleton remains, which is just an option because we cannot be certain that that was the face, but nevertheless, it is very useful. And there are also things for the expert witnesses, and statistics is very controversial. We are going to see that when it is used in order to suggest that there should be a conviction. It is not controversial when it is used by the police. Yes. And then we can find tools for anatomy, for geology, and the blood stain pattern analysis. In a room where somebody has been killed, there are tools using trigonometry in order to see the angle impact of blood drops. Can we have the next slide, please? Yes. There are electronic noses, which use chemistry in order to detect an odor. That is very useful for finding landmines, for example. And there are tools for environmental forensics, for example, of pollution by industry, and also forensic engineering in order to find why a building or a bridge has crumbled. And there are identifications methods, then evidence. There is a controversy among statisticians, but also fingerprints. Now some people understand that there are not such sure identification tools as was used to be thought. And there is the virtopsy procedure and a very advanced tool of three-dimensional visualization of anatomy for autopsy. Can we see the next slide, please? Virtopsy from the University of Bern is used for several kinds of users. It is intended to reduce the need for invasive examination. There is very much medical imaging. It's not just a static image, it is the dynamics. For example, there is animation in order to check a conjecture whether a person on the floor was killed because somebody stamped on the chest. And the very fact that you can have data generated and stored and quickly sent to the experts in high quality of the image, this is a very good thing, but there are also legal aspects that were taken care of. The next slide, please. Yes, for example, inside the virtopsy, there is the VirtoBot system, photogrammetry, tomography postmortem, magnetic resonance imaging, tissue sampling, but also there is the workflow, there's a visualization, and radiologists and pathologists would use it differently than medical laypersons, such as in courtroom situations. And this can be used in order to present the evidence in court. Can we have the next slide, please? Yes, artificial intelligence methods for evidentiary reasoning benefit from inference techniques from artificial intelligence that in turn draw upon non-classic logics. There is much legal scholarship about evidence, and this contributes to the computational techniques because it is very important that computer tools for the task would not be built without considering unintended consequences, such as that part of the legal scholars would refuse to accept the validity of the tool. We're going to see more about that. And can we have the next slide, please? Yes. And the dynamics of inference, there are various tools, for example, jury modeling, and tools for representing and processing the narrative and trying to see which explanatory narrative for a crime scene is more plausible, which is not the same as more probable. And can we have the next slide, please? Next, yes. There are various kinds of argumentation, because when we have an adversarial system, like in the Anglo-Saxon jurisdictions, very heuristic because it is conflictual. You are not trying to persuade your adversary, but to force them into some agreement or then to convince the court. But on the other hand, the court itself wants to learn through the argumentation, so it is inquiry, information seeking. And next slide, please. Next, yes. Wigmore chart notation is probably more useful than the Toulmin charts that are used more by computer scientists. You can develop your arguments as a graph, and there is a notation. Next slide, please. Yes. There are various conventions. Next slide, please. Instead, Toulmin is based on this basic pattern. You have the data, the qualifier that is often a verb, and the claim. And the claim has a warrant, and the warrant has its own backing. And then there is a rebuttal, for example, a counterexample. Let us see the next slide, please. For example, a college teacher may always borrow 10 books, but a counterexample is he didn't return the book or didn't regularize. And the backing for the statement is the academic encouragement to use the books. Can we have the next slide, please? For example, another example is that lift doors open only if a technician is doing that, when the lift is in motion. They never open when the lift is motion unless it is the technician because of the danger. Can we see the next slide, please? You can connect several Toulmin charts to form a richer graph, but I would say it would be very useful both for prosecution and for the lawyers to build their argument using the Wigmore charts. But there isn't enough awareness of that. And next slide, please. And next slide, please. Let us see what we are going to do. We'll see models of reasoning about evidence, and then there are meter models for shift of opinions in the mind of adjudicators, such as the jury, when the information is coming in, delivered in court, for example, and then a distributed belief revision model for this dynamics. There are models of juries, and then there are also tools for modeling the reasoning about a charge and the explanations, such as in Canada, the ECHO system of Haggard, and my own alibi system, which is a kind of I call a planner and also explanation generator that seeks, in the best case, exoneration. Or the second best is to produce an explanation with a lesser liability. Can we have the next slide, please? Models of juries. There are United States excess, even according to Professor Twining here in London, even though also Britain has juries. There are quantitative models, and there are qualitative models. There are probabilistic models, algebraic sum models, stochastic process models that are more or less mathematical. But let us see the next slide, please. What is the task of a juror? The jury receives instructions from the judge on the procedure and on the verdict. And then the juror has the task of learning from both. It has to evaluate the credibility, but then evaluate the implications, construct the sequence of events, and evaluate again the credibility if there is more evidence and some admissible evidence has been selected. So the credibility is updated. And if there is no more evidence, there is the pre-deliberation judgment. And can we have the next slide, please? The ecosystem seeks explanatory coherence. This is a kind of reasoning called abductive reasoning, which is inference to the best explanation. He developed simulations about jury reasoning in cases that were already adjudicated, such as the Payer case in California and other cases. A policeman who stopped arbitrarily on the motorway lonely women drivers was accused of having murdered one of those women drivers. And Vanguard, who is a philosopher, actually developed a neural network, a computer neural network, having the various hypotheses as a node in the graph, which is the neural network. And the initial values for the hypothesis, their credibility is likely. But as the neural network evolves, the credibility varies. And there have been trials to re-engineer ECO, and the software system gives a verdict, which is a simulation that managed to be like what the jury decided. Can we have the next slide, please? The next slide. This is a artificial neural network. Here it has in the middle a hidden layer between an input layer nodes and an output layer of nodes. And can we have the next slide, please? And there is a category in artificial intelligence which is called belief revision. There is also a method called assumption-based truth maintenance systems. We applied that in a model of belief revision for proof in criminal cases. Can we have the next slide, please? Consider the arrival of new pair of the source of information and of the information itself. That is, you have an item of information and there is somebody who provided it. And then this goes into the knowledge base, a database, as a set of pairs of source and information. Then an ATMS-like mechanism is applied in order to find all minimally inconsistent subsets and all maximally consistent subsets of those pairs. And from that, a set is generated of the maximally consistent subsets. The idea is that the more you have consistency, the more that is plausible. Can we have the next slide, please? From the maximally consistent subset, there is an application by using a method called Dempster-Shafer. And you apply also Bayesian conditioning to the revised set of pairs because you are revising those sets. And you generate the set of pairs information with its credibility score. Then you apply a ranking algorithm. Please, the next slide. And then, having applied the ranking algorithm, you generate a ranking of preferences on the maximally consistent subsets themselves. So you can find what appears to be more plausible. Can we have the next slide, please? Distinguish between a revision of information in a static situation and updating when new facts arrive dynamically. For example, we have a situation when a serial killer, for example, makes statements for the public and the police, and that is a new situation. Or for example, when the Red Brigades kept Aldo Moro, the politician, imprisoned before killing him. There was a time when, in order to deviate the inquiry, they said that his body was in a lake and it was not found there. And they reverted to their usual messages. The next slide, please. The next slide. Later on, those in the audience who would like to have a copy of the PowerPoint file can have it. I'm very glad for them to have it. The models of juries, these are the quantitative models that I had mentioned. And please, the next slide. Initially, the meter starts at 0, assuming that the defendant is innocent, and the meter is modified gradually as further elements of proof are introduced to the court. This is not a kind of tool that is used in the court, but it is used in order to reason about judicial decision-making. The next slide, please. Next slide. 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 Yes, there is a caveat. It is important to understand that jury decision-making quantitative models are limited. There are cognitive models, and besides, there shouldn't be an excessive focus on the juries. At any rate, such models also applied when the fact finder is the judge and not a jury. And can we have the next slide, please? Yes, a problem with juries is that it is sufficient for a liar who appears to be cogent to sway a jury, but also sometimes a witness is sincere, but is covering false memories because another misguided person, a psychotherapist, thought that these are real memories that they are not. Actually, that is a danger. It is recognized, and the scholar who did most in order to recognize that is Elizabeth Loftus. The next slide, please. Let us say something about alibi. It is a program that impersonates somebody who is accused. The input is a simplified accusation. If it manages to deny altogether and give another explanation, okay. But then, if not, it's tried to say, I'm not as liable as you are saying. Let us see the next slide, please. it is both a planning system and explanation generator. It takes the charge and decomposes it as a tree. It separates the action from the moral or judicial interpretation. If the accusation said he stole, he says, well, he took. But saying that he stole, you are interpreting the circumstances. And then it tries to decompose the pieces of the decomposition into another tree that leads to another explanation of less reprehensible actions. And at the root of the tree, at the very top, you find an explanation that eliminates or reduces the liability. Let us see the next slide, please. We are going to see an example of explaining away an attack on a jewelry. Once I showed that, and there was actually a jeweler in the audience. The accusation says the suspect threw himself on the glass window, he broke it, he entered the shop, shot and wounded the jeweler, seized the valuable, and ran away. Well, here, Alibi tried to explain piece by piece. Let us see the next slide, please. I broke the window either because he says it was an accident, I was pushed, or in order to play the hero. I heard strange voices inside and I came in to help. If it said I was pushed, I broke the window, well, I did that damage. I wanted to come in and leave my coordinates, write down my address and my phone number so they can contact me. But I didn't find a pen and paper, so I opened the cash register to find the pen. The next slide, please. I shot and wounded the jeweler. Either the gun, which was carrying legitimately, fired accidentally, or I fell and it shot. But the effect was the jeweler was wounded and helpless. Next slide, please. The fact that the jeweler was helpless and wounded had two effects. The property needed guard, and the person, the jeweler, needed urgent medical care. Alibi says, I am not a medical professional. I had to run away in order to find medical help. And I had to run because it was urgent. I took the jewels because if I ran away, nobody would guard the jewels because the jewelers could not. I took them in order to return them later. Can we have the next slide, please? Why does it sound unconvincing or even funny? Because there are so many actions that each lends itself to a damning interpretation that taken together, the damning narrative seems obvious. In this case, Alibi had to try hard to take apart the whole constituted charge differently, but the fact is that it is so damning and explaining it separately, well, it tried hard and it sounds funny. This still is from a film called 400 Pinocchios. You know that there is the story about the nose of Pinocchio who grows long because he was insincere. In this case, Alibi seems to be the impersonation of an insincere suspect. Next slide, please. It is the fair fact that Alibi was trying so hard that makes the explanation seem funny, but this is an extreme case. Sometimes it is interesting to examine the extreme cases because it tells you something about the normal cases. Next slide, please. Actually, after I gave a lecture in Italy about alibi, and part of the audience was a lay audience, there was the leading Cosworth and gag cartoons weekly in Italy started to publish cartoons that seems to be inspired by the idea. Somebody was saying the grapevine, there is a software piece that invents pretexts. And indeed, he's saying the husband, I'm preparing on the computer a program of various pretexts I do use when you'll be mad at me. Next slide, please. Or here, another cartoon shortly afterwards, the year later said, it's his fault, he pushed me. And next slide, please. I didn't manage to read the price through the clouded glass window, so I had to break it in order to read. Next slide, please. Here, another cartoon still from that weekly. It's a misunderstanding, Your Honor. My client didn't intend to rob the bank. He just wanted a loan and was showing the submachine gun as a pledge. The next slide, please. The next slide, please. Next slide, please. Yes, there is AI processing of narratives that analyzes and then replies to questions, or then also generates narratives in natural English or other languages. That has been going on since the 70s. In practice, you can have shallow processing, which is practical, or then deep analysis, but then it has to be a focus on a shorter narratives and more specialized. Next slide, please. There are several tools that can combine, if applied to law, the techniques of reasoning about the legal evidence from artificial intelligence. And some try to combine that, for example, Floris Beck's, to try to combine the analysis of the narrative with argumentation. And in the 70s, there was the conceptual dependency school, first at Yale and then at Northwestern University. And there were also tools about adversary arguments, Abdul Ilana, in the 70s at Yale. Can we have the next slide, please? And there are several kinds, which I actually reviewed in detail in my book, of kinds of story processing. And I think what is very promising now is the approach of Floris Beck's, combining stories and arguments in sense-making software for crime investigation, and Beck's and Ben Schappen's project concerning persuasion stories versus arguments. Next slide, please. In my own episodic formulae system, which was inspired by the conceptual dependency school, it was applied also to a case of corruption with a team in corruption analysis. We developed the formula of the narrative of the Watertime project that analyzed the case of corruption with a conviction in a French court in a contract of the city hall in Grenoble when the city water supply was privatized, and later it was remunicipalized, that is taken back by the city hall. Next Next slide, please. Yes, there are software for procedural support. For example, for the prosecutor and examining magistrate in Italy, Daedalus was developed by Carmelo Assaro in the 90s, and he did it single-handedly using the software that in Microsoft. And actually programmed it by night, but it was so successful that all prosecutor offices in Italy came to adopt his system. In practice, when he works, he types into his systems. It tells him whether he forgot something, whether a step is not yet valid because something else has to be done. And it also helps with calculating fines. And it also has documentation in order to show that when the examining magistrate ordered the police around, things were done properly. Can we have the next slide, please? This is, for example, how he used it for plea bargaining. In America, plea bargaining is very frequent. In Italy, it used to be anathema, and then it was adopted. That is when we see that it would be risky or costly to go to court, we can agree with the suspect whether they are going to admit to a lesser charge and they would get away with a fine. And can we have the next slide? Both legal people and computer people together unintended consequences, because that can be very harmful. Another thing is that remember that misusing or misunderstanding what technology can do for you can even cost lives. And if you want to have the PowerPoint file, you'll find about that. I wanted to say that there are also tools for cost and benefits of litigation, or for the prosecutor of whether it is convenient to propose a plea bargain or to go to court. I have a question from the audience, please. Other questions?
Ephraim, many thanks for your very interesting talk. We will now have the QA session, and I will ask the audience now whether there are any questions or whether there are any comments concerning your talk. So the floor is open for questions, please.
Hi, Ephraim. Thank you very much for your talk. I was just interested in one of your slides. You had a very interesting diagram of the task of a juror, and you had like a circle in the middle with the different procedures evaluating the credibility of evidence, the implications, and so on. And I was wondering if there are any, if you know of anything that helps jurors to evaluate the credibility of evidence that is generated by artificial intelligence. Is it generally taken as just true, or do they have any kind of way to make a judgment?
It would be too cumbersome for them. They should not be exposed to that. Even when you have statisticians in court, very often the jurors misunderstand what is being explained, and even the judges misunderstand the statistics, the fine points. There are famous things about that. And for example, even those legal scholars who warn about not to use statistics in order to reach a conviction, they say that if you use it in order to evaluate a past case, for example, the Sacco and Vanzetti case from the 20s, they have nothing against that. But it is very important not to cause the technology and your tools to just deform, distort what you are trying to do. The tool should be helpful and not intrude in what is happening. And actually, some statisticians try to explain very plainly, also to the judge, not only to the jury, what they have to consider. Now it is understood that even fingerprints are not as a sure way to identify a person as was thought. Even DNA is becoming somewhat problematic. So that one has to be cautious. At any rate, when it is the police or the prosecution has to decide whether to propose a plea bargain, it's not such a problem if they use the statistics or probabilities. It is a problem if you are using it for the case in the courtroom. And also, already in the 17th century, there was a debate about that when probability calculus was invented. Bernoulli believed in that it could be done. Voltaire was against using probability about guilt. Also Boole of Boolean logic, upon which computing is based, also believed in the probabilities for law. Can we, yes. Is there any other question?
So, any other question? Any comments? So, I put myself on the list, Ephraim.
Yes.
With respect to your talk, would you say that our current legal education need to somehow adapt to the smart technologies that we have, to the difficulties that you explained and mentioned to us in your presentation? Or would you say, just let's do as always? I guess most probably you would say, no, not we need to change, but what exactly, could you give some concrete, let's say, points, what exactly could be changed in order to make the legal education fit for the problems you mentioned? Thank you.
I would say in the third year, there should be one or two courses that would help the undergraduate see what could, for example, Wigmore charts do for them in order to organize their argumentation. And then there should be a master program for a profile, a professional profile of a legal professional who goes into depth of what the various computer tools can do for them. And this would advance both the application in the practice of law and also the development of further tools. So that by all means, I would encourage legal education to do that, but also everybody involved should be careful that the technology would not cause tragedies. I remember that once I was working in a department where one night the camera in the corridor was sabotaged, and somebody in the administration saw that the last person seen on the camera was a perpetrator. That was a researcher. Eventually, a committee of the university said that is wrong reasoning. You cannot accuse him just because his face is the last one that was recorded. It may be that somebody came from behind the camera and stopped the camera. But until he was exonerated by the university, his mother died because of the anguish. And that is what happens when technology is used, but the users don't really understand what the technology can and cannot do for them. This is true for law, for security, and also for healthcare. Yes, is
Thank
there
you,
any other?
Are there any more questions or comments? Any more questions or comments? If that is not the case, then I would like to thank you, Ephraim, for your presentation and the discussion as well with respect to the questions raised. Thanks a lot, and we will have the next presentation in 2-3 minutes. Thank you, Ephraim. Thank you for coming. It was a great pleasure. Amalia, is that correct? She's online then as well, right? So our next speaker, since we moved a little bit the schedule, one presenter, one speaker will no longer present, and we moved Amalia Verdu from the University of Turku, Finland, to this slot. Amalia is a postdoc researcher at Turku Institute of Advanced Studies, and her research is focused on the effects of legal education. So her talk today will be on reconsidering legal knowledge through legal education. And we will have a 20-minute presentation, afterwards a 10-minute slot for discussion. Thank you. Amalia, the floor is yours. Welcome.
I'm very sorry I could not go there, rules from the university, but I'm really happy attending this conference, and I think it's quite interesting, and I really like it most, all of the presentations. They were very good. Actually, my title is Reconsidering Legal Knowledge Through Legal Education, but it's really related also to the artificial intelligence and how it is used, and many of the problems that you've been raising in this conference. So, for example, here, we are talking about artificial intelligence and law in this conference, and I heard many statements through the conference, something like, we are all biased, and how these apply now to artificial intelligence. Then the other thing I heard was legal reason might be manipulated by artificial intelligence. Those are one of the claims for some users, it seems, and from law people. And then the other thing is that for human it's easier to kind of deal with all the different possibilities. And the other is following the good law principles and best practices. Okay, those are things that really came into my mind now again, because I see here like a huge opposition between the human and the digital. And my question is not this really happening in society now? It's not really like part of our law, because we know that we are all biased, and we know that the outcome of many laws are biased. We know that legal reason might be manipulated, and actually that's where we learn many times at university, because they tell us good lawyers, the one who can make a good argumentation and manipulate the legal reason. Then law principles. Well, we know that many of them are discriminatory and biased as well. So I really think that it's important to look at this opposition between the human and the non-human. Okay, so I will start with education. I think I don't know if you will know this guy. He's Paulo Freire. He's been developing critical pedagogy for many years, and he's been talking about banking education, and that I think is something that we could really apply for legal education as well. And it's how we are we are giving the people knowledge, like students are banks, and we are the bankers, and we are giving them the whole knowledge that they need, but just filling up their brains. Okay, so what is the problem with this? That it's supposed a domestication, actually, of the people rather than an education. And the other problem with this is that it creates myths. And some of the myths, for example, are this freedom, universality, and objectivity. And we know that those are things that belongs to law as well. We think and we teach that a law gives freedom, law is universal, law is objective, and well, it has been already claimed the opposite as well. So the problem with this is that we deposit this knowledge through early age and training, okay? So what happened then with legal education? The problem is that in a way what we are doing is training lawyers to be lawyers, which means that we are training them to repeat the law. We are training them to memorize and to use several dogmatic law and several black law that we find in every text, okay? So at the end, is that even enough? Can we really say that we are applying justice when we are doing this? And actually, this has been already questioned for long in the States and legal education. And the problem is that this is not enough, because what we realize is that it still serves to reify inherited knowledge while hindering its transformation. And especially nowadays, with the complexities brought by the new technological and the digital developments that you all were addressing here, makes this problem even further, because we are all questioning now, is the current legal knowledge attained at law faculties adequate to meet emerging legal and ethical challenges? So if we go to this banking education, we realize that, well, legal education is part of it and is not really helping, but it's actually helping to verify traditional knowledge and is helping to reify dualities, is helping to reify and reinforce bias. And this is getting even worse now with artificial intelligence, because the artificial intelligence can be applied quicker and for more people, okay? So what happened then? That what we are doing is that we have a truth that we transmit to our students, and this truth is embedded in the concepts and in the principles of law. So should we continue teaching the same? Should we try to do something? Well, in a way, this has been already contested and it's been challenged before for feminism, for critical legal studies, for critical pedagogies, but it still is happening. And what is happening now is that artificial intelligence is giving more evidence of these problems. So how can we look at this? If we are in a more digital age, how can we pass from passive observation and critical distancing to active participation in law? Because that's what we should do, is like how we can really interfere with this problem in law instead of just being critical. I've been experimenting with this through teaching. It's an ongoing project right now. And what we try to do is to foster modes of thought without which law could stagnate and become ossified in the future. This is difficult, I would say. It's quite difficult because it's not really like you have a starting point, but it's everything. And then we have to decide where to start from. So, as I said before, the evidence it's given by the artificial intelligence software applications in law, for example, and now it's becoming very trendy to talk about the ethics of artificial intelligence and look at the unfairness, discrimination, sexism, racism. But we know that all that has been already addressed and is still there. So what we are trying to do is go to the source, is where all this truth is transmitted, which is in legal education. So we want to look at the connection between the digital technologies and the legal education, and we can look at the interactions. Okay, so what is the difference? Because as you can see here in the slide, we have interactions, which is actually more the interaction between the digital tech and legal education, what and how to use. And I want to look at the interactions. Okay, this is a concept from new materialism as a theoretical methodological approach. And this interaction is being coined by Karen Barad, who is developing agential realism. And what she says is that this interaction is understood as agency, as not an inherent property of an individual or human to be exercised, but as a dynamism of forces in which all designated things are constantly exchanging and diffracting, influencing and working inseparably. So what she wants to say is like when we have an outcome knowledge thing, it's because there are interactions, and these are interactions that are in a process of constant becoming. Which means that, for example, now that we are presenting in this hybrid format, it changes a lot how the conferences are organized. It changes how the knowledge is transmitted. And the same with the location. Actually, I think Ephraim was talking about location as well, how important it was when they were doing all these technologies. So we want to look at all this as a whole. It's kind of looking at legal education from a holistic view. Okay, so why we are doing this? Well, we are doing this because we think that everything is interconnected. And what we want to do is to look at law as something material. It's not immaterial. And nowadays, most of the researches and approaches to law are by accepting the immateriality of law, okay? So why we want to do this? Because when we were teaching, we realized that the students were memorizing and learning, okay, what was established in the faculty curricula. And actually this was a kind of knowledge that was already part of more of the A systems implemented by legal tech. However, when we deal with matters that affect the abstract subject and leave some people subjects unrepresented, such as intersectionality, sex, and gender, the student had not considered these issues before because they were not in the books. Okay, so what is happening here? What is the problem? So we were wondering, if human fails to question this concept, how can they, much less an artificial intelligence system, consider inclusiveness and intersectionalities? We realized that there were other things that were considered a person and subject, such as corporation and ships, that they becoming humanized by law. However, some humans were excluded. So if current legal education has not helped to resolve problems of exclusion because of sex, race, sexuality, and nationality, how artificial intelligence is going to overcome these problems, okay? So we thought that to overcome these problems, we needed to look at the legal education and start to teach, given the assumption that law is material, okay? What happened here? There are some other scholars who have been already trying to look at law as material. Between them is Margaret Davis, who thinks that if we want to look at law as material, we have to be aware that law, it's separated from the world, that is part of the world, is imbricated. Okay, it's part of this interaction that Bharat was addressing. And in this concept, in this context, we have to refer to everything, okay, to what is human and non-human. And for that, I think one of the presentations talking about the metaverse is a good example of this, how the physical and non-physical world are becoming together as a whole, and how they have to be, in a way, legislated. And the presenter was saying about self-legislation, but how are we going to self-legislate a place which is non-physical if still we were not able to self-legislate a physical place? So those are kind of questions that comes. So what we think to do was to create an experimental teaching. This experimental teaching address different aspects of law, but we decided that the first thing to address was the concept of person, and that we could really go through the concept of person to different aspects of law, because the person is the main character of the law, so it could lead us through all the different parts of law. What we want to do is we want to become aware of the person's individual experience, which is part of this new materialism trend. And what it means is take into account the experiences, okay? The individual experience of the people, because we know that some of them will have completely different experience to the ones we have from law. And that this could help to build a new law and could help also to overcome the gaps and the holes that we find usually in law. What we want to do also is to challenge dualist thinkings and categorizations. For example, this human, non-human, law and digital. And then also what we want to do as well is to highlight the role of critical thinking. But what we want to do is go beyond critical thinking, because we think that this critical thinking, as it's been done till now, is more negative. It's like, okay, this is bad and this is not helping. But what we want to do is to look at the critical thinking from a more positive way. Like, okay, we want to read previous legal texts, we want to read previous theories through each other in a way to look the parts that are useful nowadays and to understand law in a different way. For that, what we are doing is we are creating an utopia. And this utopia is like how we would like to see the world in the future. Why we are doing this in the classroom? Because we think that the students we have now are the future legal actors, and they are the ones who are going to decide. So they are the ones who have to learn to think and to get out from the dogmatic image of thought. They need to overcome this representational thinking and try to look differently, to be able to address what is not there, what is actually there, but it's not naming. So we think that the classroom will become a place of transformation, and that the ideas that will come up from there could be applied in the future, or at least will give new ways of thinking, or will go to new directions and roads that could open more questions. So why we decided to do the concept of person? Because we think it's the one that actually it's more intrinsic with us. We can look at the concept of person from our own experience. So until now, and following many of the critical theories and feminist theories, we know that the law is being defined by the master discourse and have decided what is a person and how is a person defined. And has been disguised within this idea of universality. However, as feminist theories have unveiled for long, that universality didn't actually was there. So this is mainly the project. This is what we want to do. And this is based also in a previous course that is called Challenging the Neutrality of Law. And in this course, as I told you, is an experiment, and we realized that it was the open entrance for many other ideas that could be combined with artificial intelligence, because we noticed that legal education can use the concept of person in law to trigger students' experiences of identity in relation to other legal issues, such as justice, discrimination, violence, victimhood, sex, gender, and liability in the physical and virtual realms. By using new materialism, which is actually the theoretical approach we are trying to use, hierarchies and binaries such as the research education, the teacher, student, the human, non-human, the legal, digital, disappear. Then an exchange of knowledge between teacher, researcher, and student learners is produced, in which the role of every person's situated knowledge is highly evident. So what we try to show through the course as through the concept of person, show to the students how everything is interconnected and how in the future things are going to be even more interconnected than are now, or we believe that are now. So that's all. Thank you very much.
Thank you so much, Amalia, for your very interesting talk. And I would suggest we will just start with the QA. And I already see Lani, please, your question or comment.
Thank you, Amalia. That was really fascinating. My question is maybe sort of part question, part comment. The project that I work on in Oxford, we are looking at some aspects of like legal education of students that are going into the legal profession. And our approach is a character-based approach. So it comes from a kind of Aristotelian tradition where we're looking at basically how to cultivate the virtues that you would want in a legal professional. And I was wondering, because you talked a lot about person, and I can't decide myself how close the notion of person is for you to the notion of character for us. So I wondered whether you ever talk in terms of virtues or character traits. And if so, whether you think an approach like that is at all helpful or promising. Thanks.
What we are trying to do, and what, well, actually, my point of view on the person is not so much attached to the concept of human, in a way. So I think I'm seeing myself into, sorry, I hope you are seeing me well. So it's more in, I would say that it's more a Baradian approach to the concept of person, that how this person is also becoming all the time, and how is something that can be re-emerging all the time without being limited by certain rules. The problem is that nowadays, the way this becoming is happening is within certain rules and norms that cannot be avoided. So in a way, what we are doing is replicating this concept. It does not allow us to get out from there. So in a way, what we have here now is more about this Platonic ideal of a person and a virtuous character, something like that.
Yes, Tanel.
Okay. So, few technical problems, but now I'm ready. There was a very interesting part to I mean, you were talking about the law as a material substance, and then you said we have to get rid of the dualistic approach, yeah?
Yes.
So what would this mean actually in legal practice? Does it mean that the structure of the regulation changes, or the narrative of law changes, or then maybe the legal practice as such changes, or how would you describe, the new era for law?
Well, law as material means for me, and I think from this new materialism approach, is that it has agency itself, that is part of, it's not a thing that is autonomous from the people or from society or from the digital, that it has its agency, and depending on the place and the time, this agency changes the outcome. Okay, so if we look at the law as material, it means that it will change everything. Actually, it will change laws. It will change the text of the law, but moreover, it means that it will have to look at the principles, and it will have to look at the cultural foundations of law, because I think that's one of the main problems we have nowadays, is that we have certain cultural foundations that are the background of law, and we hardly question them. We just kind of not even transform it. We just pass it from one generation to another. And we try to keep this binary way of thought within these cultural foundations, which actually makes some amendment, but still creates discrimination, creates sexism, creates exclusions. So I think looking at law as material means that we have to be aware of the agency of law and the agency of these cultural foundations of law, and how they have to reassess from what we know nowadays, even including this digital aspect is so evident today, and rethink it and try to rebuild it from the scratch.
Just an additional comment or remark, or even the question. Now, some German professors are talking about the need for personalized law. How does this fit with your approach?
Well, for me, personalized law means that you are taking into account the individual. But I would like to. I think it's a very good thing to look at this. I should look at it and I should see what they mean by personalizing law, because it can mean so many things. So I think important is to see what it means for them, because it's really difficult to personalize law, because if we take into account all these interactions, we realize that the outcome is multiple. It's really huge. It's impossible to kind of personalize it. So I really like, if you know the project and you can give me the reference, it would be great. So I can look at it. I think it's very interesting.
Yes, thank you. Are there any other questions or comments? If not, I have one a quick follow-up question with what Lani mentioned regarding the concept of personhood, because it still is unclear to me what your use of the concept of personhood is. You mentioned Plato, but I mean, it would be good to know a little bit more. For example, I mean, I have worked on legal personhood, moral personhood myself, and therefore I know it's a quite complex debate. Does, for example, legal personhood require something like moral personhood? Does legal personhood require, let's say, a being having agency, self-awareness, like cognitive abilities, so on and so forth? So, but with respect to what you mentioned, I didn't really see that debate reflected. So what is your take on that? Maybe a quick response would be great. Thank you.
Yeah, well, as I said, we are experimenting with this concept. So this concept for us is everything. everything you refer to, because it depending on the cultural background, it depends on the disciplines, the approaches to the concept of person differs. So what we are trying to do is to see how this concept emerge, how this concept is reconfigured within law, and what is limiting this concept to be mainly within a dual thinking. Why this, for example, when we were looking at one of the analyses we were doing was about the legal person, okay? And how the legal person is still sexist and is still gendered, okay? Because we were looking at the problem of sex and gender in law. And then we realized how, despite contesting this concept of legal person or person in law that is used in many texts, still the outcome was mainly the same. So if we want to include instead of exclude, how would we reconfigure this concept to make it more inclusive? How do we give it the instructions? How do we give the instructions to the artificial intelligence, to the deep learning? How do we give them instructions to address this concept? So that's what we are doing, because as you said, there are many different approaches to the concept of person. And when you look at law, you see how people refer to it in different ways. So what is actually the concept that the artificial intelligence is using? So
Yes.
we have questions mainly.
Thank you so much. Thanks for your presentation and also for the discussion. We will now have a 20-minute break and then reconvene 10 after 3. Thank you so much also for joining us. Okay, thank you. So, ladies and gentlemen, I'm happy to see you again. And now we will have our last presentation of the conference, which will be given by a team, so to speak, from Austria, which is composed of Ursula Niederländer from Johannes Kepler University, Thomas Fischer, same university, Stefan Kühl, same university, and Martin Starbauer, also from Johannes Kepler University. And they will present something under the topic Law in Digital Business Experience from Teaching Digital Business Students Information Technology Law. So we are very much looking forward to your presentation. As said, 20 minutes presentation maximum, and then followed by a 10-minute discussion. Thank you. You're welcome, and we are very happy to have you here.
To this very interesting conference. I'm very sorry for not being able to share my video today. Welcome to our presentation about teaching law in digital business study. We report about first experiences with 2 courses in the scope of digital business. The agenda as follows. Firstly, I would like to talk about our background and the vision of our blended learning program called MUS. Then I'm going to report about the learning settings of the course IT Law. We realized a blended learning setting and started to evaluate it. In the end, I'm going to talk about possible future developments. Where we come from and what we do. The Johannes Kepler University Linz is situated in the city of Linz in Upper Austria and was founded in 1966. The JKU is not a distance university, but it's a dual mode university with approximately 21,000 students and over 70 study programs. We're all teaching and researching at the Institute of Digital Business, which was starting point for master programs, which are respectively unique in Austria, like Web Sciences and a joint master with the University of Applied Sciences in Steyr. The study program I'm talking about today, namely Digital Business Management. 8 years ago, a blended learning concept called MUS was launched and developed. MUS means Multimedia Study Services for Social Sciences, Economics and Business. And the target was to integrate more students into higher education by means of a blended learning approach. In the concept of MUS, nearly 70% of the bachelor curriculum of business and economics are offered as blended learning courses, and 1/3 of the courses are held on campus at the JKU. The courses on campus are in order to train the social skills to discuss and to reflect. MUS offers lots of different digital courseware. For example, students can learn via video lectures, audio commented slides, as well as wikis, blogs, chats, learning programs with video conference systems. We also do lots of peer review and case studies and so on. What was the mission, our vision of MUS? In Upper Austria, many students work besides studying, and there are also some who have to take care for children or elderly persons or have other social responsibilities. So these students need more flexibility in their learning environment, especially regarding time and place. The blended learning concept of MOOC bases on a mix of different learning environments, as well as methods, techniques, and a combination of face-to-face and online activities with computers or mobile devices, video conferencing, etc. The communicational, technical, or social learning activities are supported as well. Exams are offered partly detached from the particular courses on the computer, and they can be taken in form of multiple choice tests as well as practical exams. In addition to that, peer review or business case studies are also implemented. And another important component of our system is the support through tutors from fellow students, which are trained by us as well in form of a training program. Now let me tell you something about the learning setting of the course IT Law. The course module IT Law is part of the joint master program Digital Business Management in the first year. Students in this module have to complete 6 ECTS workload during a semester in form of a lecture and a seminar. In order to meet the needs of the students who are working besides studying, those who don't in this study are quite the exemption in this master's program, and the blended learning concept was therefore developed, which consists of an online lecture and an on-campus seminar. Through online and presence activities, self-directed learning is encouraged, and interactive and social elements are used as well. So students can benefit from flexibility in time as well as space. The lecture is held as an online learning course, which is enriched by documents, videos, audio commented slides, etc. Students can also use forums or a chat to communicate amongst each other and with the teacher. The learning content is produced in advance by the teachers and provided on our learning platform Moodle, which is used within the JKU. Seminars typically focus on discussions and other interactive elements, and therefore they usually require a different didactic design, which means the learning activities need to be addressed in a different way as the lecture. Therefore, the seminar is held on campus in order to discuss and interact face-to-face. As for previous knowledge, students normally know basics of public and private law, and that depends on their bachelor's degree. The criteria for evaluation, overall, there is an exam which has to be passed in any case, as well as a peer review task, and students have to actively participate, especially during the semester, and show their knowledge in the seminar, when to discuss the different cases and to reflect. Here you can see the teaching objectives of the lecture include in-depth knowledge of the legal framework relevant to digital business, such as copyright, domain law, data protection, etc. The students should be able to solve simple legal questions and problems in combination with technical organizational solutions and legally compliant solutions in cooperation with legal experts, so that they can understand what legal experts are talking about and can translate this to fellow colleagues. Whereas within the seminar, students should acquire following skills: the application of the knowledge to specific decision-making situations in digital business, the evaluation of different technical and organizational solution options with regards to the legal effects, and the assessment of resulting risks and the options for avoiding or reducing them, and skills in research, legal sources, like legal databases, look something up in law, etc. The subject of the module, the legal issues of IT systems, like copyright, open source software, patent, databases, and specific problems of web-based IT systems, like domain names, digital signature, commercial communication. And we also talk about people as IT object, the freedom of information versus data protection, digital customer relationship, and IT-based business models, like search engines, competition rules, and so on. The learning scenario is listed in here. There are self-regulated learning phases and different materials which can be found in Moodle, like audio commented slides, videos, PDFs, quizzes, and so on. And there is also a peer review process. That means students have to evaluate multimedia presentations or videos, or they have to evaluate created exams questions, and the students have to do their tasks. And afterwards in Moodle, there is a process which allows to do the peer review process directly in Moodle. And afterwards, there is a face-to-face meeting with the students, and it's done in form of flipped classroom. So instead of making homework at home and solving cases at home, the cases are solved in the classroom. And so there is a discussion of the cases and the reflection on the learning content, and questions are asked and feedback is given to the students. And normally it's so that in February, there is a first meeting face-to-face. So there is an introduction, and we can discuss organizational matters, do the group work, and get to know each other. This is followed by an e-learning phase. And in June, there is a block seminar on 2 days, and then the exam where the students can meet again in class and discuss and reflect and solve cases. Here you can see 2 screenshots of our Moodle, the starting page in Moodle with forums and the teaching goals, the introduction and general information, and a glimpse on the subject matter domain names with corresponding content. The students have to do tasks, as I've already mentioned, during the self-learning phases, which are then evaluated by others in form of a peer review process, so that the learners are able to get feedback about the tasks they have already accomplished. In this semester, students had to create videos or audio commented slides of really chosen topics in the scope of digital business law. Here you can see 3 screenshots of students' work, which are shown. 2 of them did a video and 1 a Prezi presentation video. It's like a brand bidding and one student took a case about a photo in classroom, which photos can be displayed online and from students. And they had to do it on their own. They had to give us the case or the topic they want to choose, and then they had to do videos or audio commented slides. In former semesters, I forgot to say, in former semesters, students had to create cases by themselves and others had to solve it. Or we also tried out that students had to do to create exams questions, and their colleagues had to evaluate these questions, also in form of a peer review process. And also students had to conduct peer learning in form of multimedia presentations in group work, and to evaluate the work of the fellow students afterwards in order to increase their evaluation competency. We began and are still evaluating the two courses. I would like to show you in short the very first results from an online survey which students who created exams questions filled out. Here you can see some findings about the lecture and the seminar. Overall, students liked both forms of courses, although the seminar, where students could ask questions, for example, about their own problems with GDPR at work, was the favorite one, and the majority wished for more e-learning courses. The large part of them stated that the amount of study material and the level of difficulty is just right. As for the future, students wish for more exercises and examples or cases, and nearly half of them would like to have game-based learning elements in the scope of IT law. Asked what students liked about the two courses, most students answered that they liked the flexibility concerning time and space through online learning and the discussions and reflections of the cases in the seminar. Some statements of the students are shown here. As you can see, they liked e-learning, independent learning, the discussion. We also wanted to know which improvements the students suggested. Some of them responded that they would like to have more examples for multimedia presentations and exams questions, and a detailed description of how to create questions, and feedback loops as well. The last question, what is planned and what are the lessons learned? At the end of our presentation, I would like to talk about future developments and the lessons learned. We are currently working on the integration of badges, which can be used in other environments as well. And we plan to integrate microlearning elements to support the students in their preparation for the exam. So students get a block of single choice questions, and they're able to do this through our app, MyJKU, which is shown on the right-hand side. And they can do these micro-learning questions on their smartphone through the app in future. Because students wish for gamification elements, it could be possible to use Moodle to offer some elements like Bloomberg's taxonomy, like ratings, and so on. And this could be also integrated in the MyJKU app. For our further research, we want to evaluate our courses and the lessons learned, if introducing new ways of learning, such as peer review or creating exams questions, students really need detailed information and many examples, like the perfect example and concrete guidelines in order to be satisfied and to know exactly what to do, because many students gave the feedback that they would have needed more examples and more detailed information on the course. And that's the most important lesson learned, so that the students really need to know what to do and in which way to do. So that's our presentation of the first experiences from our courses, and thank you for your interest.
Yes, thank you very much for your presentation, which was really interesting, and I hope that we will have some comments and questions concerning your presentation. Are there any comments and questions? Yes, please, Lani.
Hi, thanks very much, Ursula. This is just, I was really interested in what you said at the end about students requesting more guidance on how to create exam questions. And I was really cool that you're getting them to create the exam questions in the first place. And my own research centers a lot on questions and questioning and how to ask good questions. So it's just really like an invitation to maybe talk at some point about that, because I'd love to see what you've done and maybe also offer some thoughts.
I would also like to know your experiences because it was a very interesting experience. And many of the questions we just couldn't use. Either they were too easy, or you could find out the right solution by guessing and so on. So that's a very hard task to create questions, and it's even harder to get students as far as to get some questions which could be used. But it's also very interesting that they liked the evaluation, because they had to evaluate the questions of the other students as well. And so they could learn from other students and other questions as well. So they had to evaluate, and then they could rearrange or rewrite the questions again. And they did. So the quality was much better afterwards.
Just follow up quickly. When you set them the task of creating questions, what did you tell them about how the questions would be used? Did you tell them that, like, they may or may not be used, but you might use your own questions as well? Or was the idea that all of the questions they were going to answer would come from the cohort?
We told them if the quality is good, they could be used. And so they were very eager to create good questions, because they thought they could learn them and they have an advantage. But normally we don't give multiple choice questions. Normally we have just pen and paper tests, exams, because we give cases or no questions which could be answered with yes or no. In law, that's not really possible, not satisfying, let's say it that way.
Are there any other questions and comments? Yes, please, Tanil.
Yes, I would be interested what kind of new methods of teaching you kind of see for the future, and if there could be something like hands-on practical exercises, you know. And also the other part of my question is that as there were different disciplines related, did you have any kind of difficulties of understanding each other or not?
In this case, not really, because the students chosen very carefully, so that there is a common background and common knowledge as well, let me say it this way. So they all work, and they all have already worked with, for example, GDPR and so on, so that there is some common ground. The problem is there are no law students, so the cases we can give are very simple and very small. So we can't get them to work on a case the whole semester, very intense. It's also just small parts. And in future, a very good question. I hope it's possible to get gamification elements, because the students seem to prefer learning this way. And if we can get them to be interested and to be motivated, I guess that's the best way to teach law. Because the students who are coming to us are from digital business, and law is just another subject matter they have to learn. And if we get them to be interested and to see, okay, that's relevant for me in my everyday life and in my work, etc., and it's fun learning it, then it's the best way to get good grades and get them to learn better and to build knowledge for a longer period of time.
A nice pragmatic approach, yeah.
Are there any other questions or comments? If not, I put myself on the list. It's a kind of follow-up question to what Tanil asked in the beginning. Namely, did you do anything different teaching the digital business students technology law compared to other disciplines? Because since our main topic is legal education, and the question then pops up, if we can, apply different methods in teaching in order to teach AI more sufficiently and maybe in a better way. So do you have any comparison? You mentioned something with respect to your evaluation, but is there anything else you could share with us? Are there any differences with respect to this particular topic, technology law, or what is it about? Thank you.
I studied law, and we had a lecture where we had, in Austria it's called Vorlesung, which means reading, and in some parts the professor came in and read the text. That was the lecture. And we had to learn, and then we went to the exam and did the exam. And in some courses, we had cases which we had to do as homework or discuss in classroom. And so that's a totally different approach of teaching. We sat in the lecture and listened, and then we wrote the exam. And so I'm now working in the Digital Business Management Institute, and here we do very much business cases. We have many virtual learning groups and teaching with different universities in different countries and doing business cases, peer review processes, and we are trying out very many different ways of teaching. So the law I was taught is totally different from the way I'm teaching now. And since COVID-19, everything changed. So I think at our university, many courses, lectures are done via Zoom, but I don't think there is a very different approach on teaching. So there is a teacher talking and the students are listening, and we are trying to do very many self-studying processes and a reflection, social learning, like group learnings, and quizzes, and so on, so that the students can learn in an interactive way and through peer learning and so on. And
yes, thank you very much. And are there any other questions? If not, then thanks again for your presentation and for the QA session. With respect to what follows, so to speak, I think it would be good to have just a brief roundtable discussion. And I would like to ask Lani and Tanel to participate in the round table, and then we will have maybe a quick chat and take other questions, and I think 20 minutes, 25 minutes should be enough, and then we can close the conference as well. Thank you. So it has been a quite long day, let's put it this way. And of course, when we think about the main topic of the question, of the conference question, the future of legal education, how should it look like? Maybe a brief response from each of you, and then see how things go. That would be greatly appreciated.
Yeah. So I've really enjoyed today, and I've particularly enjoyed the sort of coherence between the various different talks that we've been talking on a similar theme, but without, but coming from lots of different perspectives. So I think the future of legal education remains a problem to be addressed. And I'm quite hopeful that sort of a number of the different approaches that have been suggested today can be, because it seems like we've kind of traversed some ideas around actual education, like that last talk in particular, some suggestions about how to do the actual pedagogy, and then some like more foundational concepts around what exactly we need to worry about in the future of legal education. I think one of the things that at least Tanel and I have chatted about a little bit today seems to be clear to me is that it does have to be different because the context that lawyers and legal professionals are operating in now is so significantly different, and the challenges are importantly different to the past. And I think that however we move forward, it does have to be with respect to some kind of change in response to those technological challenges.
Yes, I think this is really a good question. I think in a short term, I think the law schools will not change. It means that they try to keep the business running as they had last 50 years or more. So it is very, very hard to change the narrative. But in a short term, I think also the innovation for the legal education may come in three ways. And the one is that the government understands the need and funds certain kind of trainings, or maybe proposes some projects to find out how to handle the rule of law and digital society at the same time. Then EU may understand that there is a need for revolution, certain kind of revolution. And then I think the third option is that people like we are here who are interested of the, let's say, the new era, and maybe be opinion leaders there and set the frames. We take the initiative and cooperate to each other. But in long term, I think in long term, and I don't know what is the time frame because the innovation happens very rapidly. So I think in long term there will be a collision between so-called orthodox legal education and then the let's say innovation or let's say the new technologies that are used for society. So that the legal education has to change because otherwise it's useless. But it would take time.
Just a quick comment to that. Would you not say that this is a bit of a dire situation because the changes, the technological changes happen now? So that means when the law schools still stick to their orthodoxy, they may just lose the battle. You mentioned earlier the judge, the more senior judge, who is basically, I wouldn't say unskilled, but who lacks the skills or proper skills to apply AI in the legal decision making. Though, if AI is used as an assistant tool, it might cause a problem because, as we have seen with the Compass case, the judges simply don't know what's going on there. Why there is a bias? There shouldn't be a bias because technology is neutral. That's that might be the reasoning behind that, right? So it seems to me that there need to be a very strong answer to this sleep, legal sleep of law schools, to face the innovation and to deal with the situation properly, and to do that as soon as possible.
Maybe just quickly to answer, I've seen the situations in different law schools that I'm related to, or I was related to, and then I think the problem is that many people they don't make a difference of interdisciplinarity and multidisciplinarity. So I think we can be successful in the context what we are actually having discussion to be innovative law school only if we are using interdisciplinarity, that the lawyers know coding a bit, they understand the IT and the societal needs, they know the main trends, green turn, gig economy, things like that. But unfortunately, I think the older generation doesn't want to cope with that. So I think this is a question of also the medieval nature of the university in a way, because the established professors, you know, they are not too young, so they have to keep their positions. They don't want the competitive party to become in power, so that's why it takes time. Yeah, and I think the key is actually the multidisciplinarity and interdisciplinarity to talk about this. I've seen in some, let's say, orthodox old-fashioned law schools that they try to teach IT law, but then they hire IT guys to talk about IT, and they teach law as previously. So what we try to do is to mix disciplines, really to get people who are educated in IT, but also in law. So we have interesting cases where the PhD in IT comes and studies our master and then stays with us. So I think this is something that is a breakthrough. Yeah.
It's all right. It's been a great conference, great discussions, and I think that, you know, for training of lawyers, you don't need lots of funding into technology, anything. I think that it's important that you teach people to think and to evaluate information. And the model has shifted nowadays where we can access lots of information. It's important not to learn things by heart or remember, which might have been a very valuable skill to have some years ago. But now it's important to teach young people to evaluate that information, to find the right one and use it to their benefit. So even if the law schools don't teach technology law, if they have enough curious young minds and teach them to use their skills and improve their skills and prepare them for further life, they will be prepared for it. Because there will be some people that are interested in technology and they will be technology lawyers. Others might be interested in something else. And if they know how to use the skills that they have, then they have a bright future ahead of them. So I'm very optimistic.
Can I add my endorsement of that view, and also it feels to me like, as you said, Tanel, this idea of interdisciplinarity, that like philosophy has a really important role to play in that context of legal education, and in particular kind of moral and ethical reasoning that philosophers train in is not, as I understand it, this quite the same type of skill set that lawyers are typically being trained in at the moment. And it seems like that's a really, really useful skill set now that we're facing the kinds of like moral questions that are presented and have been presented at various points throughout the day. But like, for example, you know, whether a crime in the metaverse is the same moral act as a crime in the real world. these are deeply philosophical questions, and we need philosophical thinking to try to resolve them before we can do any legal stuff, it feels to me.
I would like to add that I think that the model that we used to have in Lithuania, where students in their first years used to get quite a lot of general knowledge subjects, was quite a good model. And there is a trend now that everyone wants to get the results quick. So the programs are being shortened, and the subjects that are being taught tend to be just the subject matter that is directly related to the degree. And I think that's not a positive trend, because those general subjects, such as philosophy, for example, or logic, are important, and they put a foundation. I think there is a problem, or at least it used to be when I was a first-year student here in Lithuania. And partly it was the reason why I left and studied in the UK, was because we had all those subjects, and it was great to study them, such as philosophy, logic, and so on. But no one told us why we needed that, so we need to learn everything by heart for the exam, and that didn't make sense. So that was my decision and a push to go somewhere else and look for places where I could study and understand why I need to learn something, and where I would be taught to actually use that knowledge and find it. So I think that the concept of having a 4-year undergraduate degree, for example, and having this philosophy and logic in the first year is good. We just need to look at the methods, how we teach the students, and make sure that we explain to them why these subjects are important then, and how they may benefit them in their future careers.
Just to follow up to what Tanel mentioned with respect to interdisciplinary lecturers, I think that is spot on, because then you can really combine the strength of both disciplines with respect to, let's say, smart technologies and AI, but also to implement, of course, more disciplines. You have mentioned philosophy, that is ethics in particular, with respect to really big issues like machine bias, for example, and educate lawyers. What happens if you just follow the advice of an AI tool, basically closing the eyes and saying yes and amen? No, one needs to know the story behind the issues. That means really one needs to have a good education with respect to the other disciplines as well. I think that is already a very good start, right? So we had the first question, Ignas, was what is the takeaway message with respect to the future of legal education? Given the conference theme, what needs to be changed? What possibilities do we have? We can't go on like the old orthodoxy, pushing the orthodoxy. So what can be done in more concrete ways? So I gave each colleagues a moment to think about that and to respond briefly on this question.
Yeah, so I think something that all or most of us touched upon was the necessity for expansion of education, of legal education, both in terms of the legal profession, including more of the technology stuff within legal education, but also extension of that towards the society as a whole. Well, we're talking quite a lot about information literacy and so on. I think legal literacy and specifically technological legal literacy within the broader population is going to be an increasingly important matter.
Thank you. Any questions or comments to what we have heard before? Any new insights? Yes, Kęstutis.
So, okay, I think this worked. I wanted to ask about the regulation of electronic goods. I think the example with virtual bags basically selling for more than physical ones was quite revealing, but there could be some other examples too. So suppose that you are in a metaverse and you are doing something there. You are working towards some goal. You're trying to find some collector's item, let's put it this way, that is highly valuable in that kind of virtual reality, virtual economy. And then you obtain it somehow, and whoever owns the metaverse decides to basically give it to everyone or make it available for a very cheap price, whether it's virtual currency or real currency. And then of course you would feel that you were wronged. Somehow the owners of the metaverse robbed you. Maybe you were going to sell that item for good money, so to speak. So my question is, what is the current state of regulation when it comes to electronic goods of this sort, and which way do you think this kind of regulation should go?
Well, I guess that as things stand at the moment, you would have to apply law that already exists if you want to address an issue like that. The thing is that when we move to metaverse, I think that we as a society have to decide what we value and what sort of rules we want to have there. But also, like in real life, we can find comparisons to this. It may be that you bought something really and paid really good price or paid a lot of money, and then the seller decides to, I don't know, to have a sale or something. And you would feel disappointed and you would have the same feeling. So is it really illegal or wrong because you feel disappointed in the actions of the person that kind of lives from this commercial activity? So I don't know. It's a question that could be asked and will have to be asked, and I think that we will find things how to deal with that. But yeah.
Yeah, if I may, I think there are different levels of this regulation. It could be that we are talking about Digital Markets Act, or you know, there are different trends and strategies in a higher level. But also coming back to this personalized law, I think this would also be something for the near future. It means that a person cannot actually handle his surrounding, because there are too many ecosystems that he is related to, and some others are not. So it's getting very complex. Everything is getting very complex. And I think the one, let's say, narrative or new perspective for the lawyering or lawyers is that they are helping the groups of people to handle their ecosystems, you know, to sell or not to sell, to give the data or not to give the data. So the privacy and the personal benefit gets even more important. I think there are statistics in US that people are more and more knowledgeable about that the data has a price, but still people are losing about 500 euros or dollars per year, which is not a lot, but still, if you take the US population, I mean, they are just losing this data for companies. So I think this is multi-level question of how the big economies survive, and how EU protects itself against, I don't know, US and then China, and then the personal level, you know, how something maybe in between, but there will be many levels, I think. Yep, this is my kind of understanding how the world may go.
And I think it would also kind of depend on the governance model that we end up with. whether we end up with a sort of more decentralized, perhaps NFT kind blockchain-based model of governance, which would provide at least some degree of independence from the large platform providers, or whether we go fully centralized. And in this case, platform creators would certainly have very big power indeed. So I think it's also to a large extent a question of how it goes, how it develops in the future.
Maybe to give one example to continue that, the platform setters, we have a gig economy like Bolt and Wolt and many others. So they basically, some say they steal the money from the state, because they don't pay taxes. But, okay, situation is changing, but we prepared a project in our law school that said, okay, let's replace these gig economy players, give this power to the local communities, the city communities, so that they would actually compose a kind of company, even maybe earn the money, but rather they could keep the social services sustainable and going in this community. So it's maybe also one trend to compose the communities that are self-sustainable and independent from the private platform like players or setters.
I do have one quick question to Tunnel, because in his function as director of the Tallinn Law School, you mentioned previously that the law schools might stay rather conservative. Though, as you're not conservative, I think you're already working on let's say, modernizing the way how law can be taught. And it would be maybe interesting also to hear from you what you have done in the past in order to make this change happen, to improve legal education for lawyers against the background of the smart technologies. I think that would be really interesting for all of us to hear.
Maybe I don't have this very systematic overview of that, but the first things that come to my mind is that in my law school, there are also employees who are not lawyers. I have political scientists, I have philosopher, I have an IT guy, then I have one engineer, and they are all working for the law school. Because they are smart people, they can find the projects that also include, or these projects actually need the ethical and legal aspects. And I could not find them without the help of the representatives of those specialists. Another thing that I'm doing actually now is I'm trying to associate the law school with the legal, not the legal practice, but let's say innovation world. So today I presented a list of companies who are doing something for e-justice. And we are now trying to have a close cooperation with them, because I feel they need us. When we had the first meetings, then they didn't know about this world that I was talking about. And we don't actually know what are these technical possibilities to use data. And maybe third thing is also, we also, as there is this, borderline between the, let's say, orthodox law schools who want to keep the format for the market as it is, which is impossible in long term, and we want to create a new market, or be at least there if the new market will be established. And this is also difficult to do it alone. So I established with good colleagues TalTech Legal Lab.
So we try to apply not only for research projects, but the projects that are offered by the private companies and public institutions, not only from Estonia, so that we could be the think tank or the center of, let's say, the hub for opinion leaders. If there is any question related to law and tech, they just know that they may turn there. And it's certainly cheaper than to turn to old-fashioned, let's say, law firm and pay, I don't know, 200,000. We could do it with 20,000. Because we also get salary, and this is like a, a special project for us. So I think closer to the practice is the slogan. Yeah.
Thank you very much. Any other comments? And if this is not the case, then I would thank the participants of the panel, and will briefly say some concluding words, so to speak. So I think it was an important event today. Unfortunately, not too many in the room, but hopefully many more online, so to speak. But as we speak, we are preparing within our group, research group, a book on the future of legal education, and which will be used also for teaching at our Faculty of Law. At least that is the hope at the end of the day. And I'm happy to see that quite a few of the points mentioned today during this conference have been dealt with or examined also in our book. So it is then really a timely publication, and together with the input, the book is not yet ready. One can still add a little bit. Is definitely a very, very helpful and valuable thing. Then, of course, I would like to thank all speakers of today. It was a great pleasure to have you and to hear more about your views and your particular approaches. And also, of course, the audience for your questions and the QA sessions. And then last not least, I could have not done it myself, of course. There is a strong team behind me, and I will just name them, which is Giedre, we have Adrienne, we have Vlad and Kestutis, who were part of the organizing team, and who really did a good job in putting everything together so that we have a smooth process of this conference. So so thank you very much for this organization, so to speak. And then I see two things which are for our foreign speakers, because the VDU is always giving a little presents to people from abroad. So Lani, that is for you, a gift, and also you're welcome. And also Tanel here, thanks a lot. And as you know, we will have a dinner at 6 o'clock in Vista Puerde. So that will be then in 1.5 hours, something like this, but we will go to a pub before, so if you want to join, please do so, and we will do that. So thanks a lot to all of us, and